Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-7033, Isaac Harris et al. Versus Medical Transportation Management, Inc., appellant, versus Star Transportation LLC et al. Mr. Andre for the appellant, Mr. Kirkpatrick for the appellees.
Good morning, everybody.
Good morning. Jean-Claude Andre on behalf of the defendant appellant, Medical Transportation Management. It's incumbent upon me to begin here by stressing truly how extraordinary the district court's order in this case was with respect to both Rule 23 and the FLSA. It is undisputed, this is in the district court's own words, that the putative class members here were employed by 80 different transportation service providers, each of whom negotiated an individualized rate structure with MTM. Some were paid salaries, some paid hourly plus overtime, others paid hourly without overtime, how much they were paid, whether they were paid for breaks, that many were employed by several different transportation service providers at different points in time, that even individuals working for a single transportation service provider were paid at different rates at different times.
Indeed. So how would you recommend the court interpret C4?
Yes, Judge Rogers. We would recommend primarily that the court interpret C4 as not permitting a quote-unquote issues class. And we have a number of reasons why we think that's appropriate. In particular, if you look at the text of Rule 23.
Wait, can I back up and just rephrase? I don't want to, I am sorry to interrupt, but just to follow up on a question, I understand your arguments. We have lots on that, on why you don't like the approach the district court took. And I think this is what Judge Rogers was asking, but she'll tell me if I'm incorrect. What do you think C4 does affirmatively?
I think C4 is a severance.
That is precisely what I was asking, and I thought you were starting to answer.
Sure. C4 is what I would call kind of a severance provision or a pruning provision. And in fact, if you go back to the 1966 Advisory Committee notes, when C4 was first promulgated, that's exactly what the Advisory Committee said. The Advisory Committee said that C4 is designed for the case where damages are too complex and too individualized, but they should not defeat class certification. So once you have a damages class under Rule 23CB3, you're not going to permit that class or prohibit that class from being certified because damages are messy. C4 allows the district court to sever off or prune off the damages and leave that for the end of the day. Of course, that's been reinforced time and time again since then, most recently in Tyson Foods, in Amgen, and in Comcast. So C4 does have work to do here. It's not, as both plaintiffs and their amici say, rendered a nullity by our position. To the contrary, I think their position renders B3 a nullity because, as this case illustrates, a district court can go all the way down the road to the earliest possible common question it can find, even though there's no predominance whatsoever with respect to the entire action, let alone any particular cause of action. The district court can go all the way down to this very preliminary question and say, well, that's a common question, and it predominates as to itself. And so therefore, I'm going to certify that issues class. And that renders... So
you agree that a court can, under C4, have a liability class, even if damages are going to have to be individually determined?
Absolutely. I'd be flouting the Supreme Court if I said otherwise.
Sure. But doesn't just the text of B3 already do that? Okay, for common issues of law or fact,
I don't
find whether they predominate. So whether that legal question, that common question of liability, may predominate over what you called the messiness of didn't certify the class based on certain questions. And then your position is that C4 tells the district court under B3 or presumably under, I don't know if we could do it under B1 or
Correct.
not, but we'll just focus on B3 here, allows them to carve, to use, carve other issues. You said maybe like an affirmative defense.
Correct.
Or something like that. So what is the legal test for when there's been too much carving? I think that seems to be your position here. You don't quibble with the fact that courts can carve out issues.
Well, to have a couple responses to that, if I can go back to respond to, I guess, your antecedent question and what you mentioned at the beginning of your most recent question. I think the answer to why common questions of law or fact doesn't deal with the damages concern by itself and why you need C4 to help it out is because B3 talks about common questions of law or fact that predominate with respect to the controversy. The end of B3 talks about the controversy. And in my view, that's the cause of action at minimum, if not the entire case. To go to your point about whether there was just too much pruning here or too much carving, I mean, absolutely there was. And so I don't want to, I guess, swim away from our primary argument too much because we do believe our textual reading is correct. But what I was trying to get at the outset here is that what the district court did, and if this court were to affirm, and presumably in a published opinion because it's an issue of first impression for this court, it would be the most muscular application of C4 that any appellate court has ever adopted. All of the other cases that plaintiffs rely on as framing supposedly the other side of the split, that we're on the short end of here, all the other cases involve some common event that allegedly caused injury or some common practice or policy that allegedly caused injury. And then the question in that proceeding was, did the defendant do it? And is the defendant legally responsible for that? That's not what we have here. We have this very early preliminary question. And I was trying to think about what other kinds of legal questions do courts deal with where they can invite an early summary judgment motion under Rule 56 because summary judgment can be brought at any time. It's like preemption thinking. It's not so much like personal jurisdiction, not so much like venue, not so much like forum nonconvenience. Those are all early issues too. But with preemption, oftentimes that cannot be resolved under 12b6. It has to be resolved under Rule 56, but the court deals with it early that way. That's what I think the district court should have done here instead of doing what it did, which is, again, carve out this little issue that doesn't resolve any question of liability as to any cause of action, let alone the entire case.
Sure, but then that sounds like, again, all you're agreeing with is C4 lets you to separate liability, and you would say total liability, not this sort of threshold liability question the district court identified here. So you're saying the total question of liability and damages can be separated. But I thought you added, and correct me if I misunderstood, that something like affirmative defenses could also be severed. So what I'm struggling with is how would you write the legal test for an opinion that would say the liability damages severance, that's okay. Affirmative defenses, that's okay. This is not because.
Sure. Right. I would say I know I'm going over my.
Don't worry about that. I'm sorry, I'm taking so much time. I'm just struggling.
Where there is a recognized issue that is recognized as being necessarily individualized. So again, like I said, reliance, affirmative defenses, damages. That is what C4 is intended to do. And that is what C4 may be applied to. There is no such thing as a writ large issue class that allows, and sticking with the carving at the joints, pruning analogy, plaintiff Samiki actually used a term that I like, that you can't julienne in this regime. And I think, that's what a district court here was trying to do. And so I think the opinion that the court would write would say, where there's a recognized individualized issue that otherwise would defeat predominance, C4 enables the court to sever that off so that a class action may be certified. But that's not a issue class, because in this case, what the district court did was pluck out this one very preliminary issue, leaving all these other questions down.
What about just judicial economy generally?
Pardon me?
Judicial economy.
So I don't think there's any judicial economy here. Either way, there's going to be, we don't know. I mean, frankly, the district court didn't articulate exactly what plan it has for down the road. But is it going to be small groups of trials? Is it going to be every one of the 800 putative class members coming in for a mini trial or a hearing on whether there actually is liability, and then what the amount of damages or liability is for each one of those people. And so we're in the same
Wait,
place.
I thought the district court I thought it was more clear than that. What the district court said is, look, on the questions of joint employer and contractor, your client, MTM, doesn't dispute that that's a one answer. That doesn't need to be individualized. There won't be an individualized answer for that you would be a joint employer for some and general contractor for others and neither for some others. That'll be one answer to both of those questions. Either you are or you aren't. And then that will be answered, and then all the individual actions that need to go forward will go forward. Put aside the FLSA thing over there too. But those will go forward as they need to, but at least this common cross-cutting question that could release MTM conclusively from any liability across the board in this action, that's what will go forward.
Yes, I guess.
So why is that a julienne rather than a permissible cut? Sure.
I think the problem is that we also have the superiority requirement here, and that requires that what the district court order be superior, not maybe be superior, but actually be superior to proceeding with individual actions. And so the prospect that my client may get out of the litigation because they are found as a matter of law to not be a general contractor or a joint employer isn't definitively a finding that this method is superior. And even with respect to the issue of whether we're a joint employer or general contractor, it's frankly it's messier than that. We don't think it's susceptible to the common proof, even that preliminary question. And so,
but the district court found otherwise on that. It would be subject to common proof.
Yes,
so that's kind of like that's something it hasn't been briefed for us to overrule that determination.
Yeah, I'm willing to acknowledge it. The district court did say in his original order denying class cert under B3, he did have a paragraph that said that at least with respect to joint employer or general contractor, common questions predominate. So he didn't quite go as far as saying that absolutely it's resolvable by common proof, but he did say that at least predominance is satisfied with respect to that. So we will take that as a given. But my point is,
I thought that was superiority, but go ahead.
Well, it was superiority, and I put it back. It's just more complicated. It's more messy.
Well, I'm sorry. I'm really trying to understand this because this seems very important. And so really what I'm trying to understand is, okay, if it's fine to separate liability and damages, it's fine to separate liability and an affirmative defense.
Yes.
Why isn't it, how do I know when it's a julienne rather than a legitimate cut, in your words? That is, why isn't it fine to separate the threshold? Should MTM walk away from this? Is there any basis, this threshold basis for liability? Are you connected to this problem that they're alleging against a lot of other companies at all? Yes, no. Why is that not a permissible decision? And then the rest of, just like, it's kind of like a liability, although it's sort of stage one liability. And then we let the rest of it go, as opposed to liability damages clean cut.
Because what the court has carved out is not first a recognized kind of exception to something that is susceptible to common proof, right? So again, it's not like an affirmative defense. It's not like damages. It's not like reliance on the fraud context. So it's not recognized. And then on top of that, even if it's resolved in plaintiff's favor, there are still all these additional proceedings that need to occur that go to liability. Mm-hmm. And so this is what the district court julienned out here is just the first sliver of potential liability for my client. And that is just too far away from.
And that wouldn't happen under your theory where reliance could be, a reliance class could be certified?
No, because I think that'd be because it's recognized as an operation of law that reliance has to be individualized. And so what that class would look like is that you actually certify all the issues. Again, I'm fighting that term.
All the questions.
You invite all the questions up to reliance. And it may be that the defendant is let off the hook at that point because, when the court either in summary judgment or in a joint trial determines that there was no misstatement or there was no duty, no misstatement, all the things that go to fraud. And then you have the reliance and damages trial.
So it sounds, is it just so you don't insist that, liability versus damages, that's the only line. And you recognize, I guess, with this reliance thing, that even within a claim, a fraud claim, part of that fraud claim itself can be divided up so that all the elements except reliance can go as a class, and then reliance can go out. So it's okay to divide up even pieces of a single claim under using C4, the C4 muscle that it gave to B3. And so why is this, the whole reason this division isn't okay is because there are still there's more than one thing to be decided after this is resolved under the cause of action. I'm struggling again with the legal text.
It's too far away from actually establishing liability because it doesn't go to the question of whether there actually was an FLSA violation here. It basically just asks whether my client would be vicariously liable for some FLSA violation by one of the 80-odd TSPs that employed 800 different drivers. And so in all of that is going to be,
I guess, but too far away isn't really something we can write into fourth, I guess at this point, into an opinion. So is it whether, the weight of the claim qualifies for class action, but just one issue doesn't? Or what if there were sort of three issues that did meet all the 23B3 requirements, but two did not? Would that be an okay use of C4?
I think it depends on what the issues are, but probably.
It's hard to have a rule that depends on what the issues are in every claim.
Again, this is our primary argument that we're probing here on, how to interpret C4. I can go back to kind of what I started with, which is our backup argument. I think at minimum, this court can look at all the cases that plaintiffs rely on. And what you can see is that, I know you don't like the phraseology, this is too far. This is insufficiently proximate to the liability determination.
Well, it's sort of hard to write opinions on the no one has ever done this, because there was a time when no one had ever divided liability and damages, and a court did that for the first time, and everyone agrees that's fine. And someone for the first time said, well, I'm actually going to divvy up this claim here and peel off reliance, and that was fine. So the fact that they're doing something in a form that hasn't been done before is not a legal test. That's what I was trying to give you. Is it a weight of the action? Is it the 3 versus 2? Is it you can only peel off one thing? I understand. I think I really am trying to grapple. I think I understand at some level what your concern is here. And there aren't a lot of examples, at least that I could find, that look like this type of divvying, but I'm really struggling with how one writes. You want sort of a clear legal rule against this, as opposed to analyzing district court's discretion to sort of manage really big, funky litigation that's come into their courtroom.
No, I understand. And again, I think the opinion that would give clear guidance would be one that said that where there is a recognized issue that otherwise would defeat predominance as to cause of action or an action as a whole, that a court may use C4 to sever off that predominance destroying issue so as to proceed with a class, provided that all the other prerequisites are applied or satisfied. And that would be how we urge the court to interpret C4. Again, the practicalities of it, to go back to your question, but what if it's 7-2? We actually do have that fact pattern. We think that the Martin case from the Sixth Circuit is wrong because it articulates a very loose standard for what C4 can be used for. But at least in that case, the court certified 7 questions and then left 3 at the tail end. And we think that's wrong because of the way it divided things up on our first argument, our primary textual argument. But it shows how here, for the district court, sever off one very early issue and leave the rest for the end. Again, it's too far, insufficiently proximate. I know I'm not offering you the best terminology to put in your opinion, but all the plaintiff's cases are like that, whether it's Russell from the Third Circuit, which again, we don't love. All these cases have examples.
Well, I'm not asking you to love things. I'm asking you, how do they violate your test? How do you think the Sixth Circuit, we're not bound by the Sixth Circuit, the other ones, how do they violate the test? Because there, at least, the great weight of the claim was left in class status. And just a couple like your Reliance example, a couple issues were carved off.
So in the Sixth Circuit example, it would violate my test because there the court left the fact of injury, proximate cause, and damages all for individualized determination. Under first principles and under our reading, the fact of injury and the proximate cause inquiries, the court severed them off for a reason because they were predominance destroying as to the overall causes of action. And so.
But you're fine with predominance destroying issues being cut off.
Damages, again, settled ones, recognized ones.
But again, settled and recognized doesn't work because some courts have to do it for the first time before it's settled or recognized. We can't sort of live in a world where we can only repeat what someone else has already done.
No, I understand. I mean, ultimately, if the issue is one that is individualized, then the presumption should be that it is predominance destroying and the class cannot be certified. And then I know, this argument is not particularly satisfying.
But from the defense side, in many instances, when you have these class actions and there's a challenge to whether or not you should certify the class, there's always this argument about the individualized damages after you find liability, but they believe that the class should be destroyed because you would have to engage in those individualized damages. Oftentimes, a trial judge will say, no, let's go forward. We've got the commonality, we've got predominance, superiority, and the class should go forward, but you can take care of the individualized damages another way. For example, having a special master deal with those particular issues along the way. So why wouldn't this be different, kind of using the same thing, kind of using that analogy for how a defense side would try to not have a class go forward?
Because again, this is a preliminary question that can potentially only resolve the liability question in one direction. Admittedly, in our direction.
But to Judge Millett's questioning, when you put forward issues, you're hoping to kind of shave off those who should not belong, like get some initial liability determinations by making definitional constructions and things of that nature in the litigation so that you know what you're going to be trying eventually.
Right. And I think we do know what we'll be trying here eventually. We just don't know what it's going to look like. But there's.
Well, I guess I should say it better. Who and what will still be part of the lawsuit?
After any preliminary determination in this particular case?
Yes.
I mean, well, so you will have 800 drivers from 80 different TSPs. What will remain is whether there actually was an FLSA violation, because some drivers, they had a set schedule, some drivers had a split schedule, some drivers were on call, and all of those variables will impact whether there actually was an overtime wage and hour violation. And then what is the quantity or the damages associated with that? Again, we're fine, if the court had just said, well, we're not fine with any certification on the front end of this equation. But if this case had been amenable to class certification and the court just severed off the last damages calculation, that would be fine, because courts do that, as you know, to Judge Charles all the time, and Comcast, Amgen, Tyson say that courts can do this. And again, going back to the 1966 Advisory Committee notes, that was the intent of C4 when it was originally promulgated.
Can I follow up on your question? So if this goes forward, I get there's going to be a lot of fighting between the direct hire companies and these employees. What questions are left to be decided let's just assume, and I'm sure you'll have lots of arguments against this, but let's just assume you're found to be a joint employer and or contractor for these purposes, so that you at least have potential liability. How many questions are left to connect you to, say, one of these direct hire companies, one of the, I don't even know what to call them, the driving companies?
Right, the TSPs.
The service, all right, so the service providers. How many issues are left between you that would make you responsible or not for what the service, again, I'm assuming all kinds of things here, service providers screwed up somehow. How many issues are left just as to your liability?
My apologies. I have to fight the question a little bit. No, I have to fight the question a little bit because the TSPs were not sued by the plaintiffs. Mm-hmm. We brought them in as third-party defendants, but they're effectively stagnant in the case. Mm-hmm. And so if the district court were to find, either on summary judgment or through a joint trial, that we are joint employer, or general contractor, then we are vicariously liable for whatever violations are found to have been committed by the various TSPs. And so the TSPs are basically then witnesses that we will be using to try to fend off any liability to establish that they're.
But you're automatically vicarious liable. Vicariously, excuse me, it's too early in the morning, self-vicariously liable.
Correct.
There's really there won't be any more questions about what you did or didn't do. It's all going to be about what what you call TSPs did or did not.
Correct.
There's no way, okay, because you're strictly liable for anything that they did.
Right.
So really, this just resolves directly sort of your status, and then all the fighting is to be whether anything went wrong or not.
Right, and the extent to which it did, if something did go wrong, which then gets really messy.
Sure.
And that's why, earlier on, I analogized this to preemption, where, I've had cases where, the district court's, I'm not going to grant your motion to dismiss here, but go ahead and do it on summary judgment, because it's that threshold question that the court can resolve, and if it goes in the defense's favor, the case is over. If it doesn't, then you proceed with the case in the normal course.
And what do you
Now,
say?
let me ask, go ahead, Judge Charles.
I was just going to ask, what do you perceive C4 to be allowed for? I mean, what are some examples that you say this rule can be used for then?
For C4? So absolutely damages. Again, that's what the 1966 advisory committee.
Anything other than damages?
Yes, no, affirmative defenses.
Okay.
In the fraud context, reliance. Trying to think. I haven't thought of every example, and those are three that.
Sorry, and you're saying.
But it's very open-ended.
Wait, I'm sorry.
No, I'd have to disagree with that. It's not open-ended. It's.
When I say open-ended, meaning that it's broad language. When appropriate, that's
Yes.
discretionary right there.
Yes.
An action may be brought or maintained as a class action with respect to particular issues. That's what I mean by open-ended. It's a broad term.
Right. But under our reading, because you have to satisfy predominance with respect to at least an entire cause of action, then C4 can't swallow B3, can't swallow the predominance requirement. And I guess that's also where our fight is. And to be clear, plaintiffs amici say that we are advocating for an entire action rule for predominance. We are not. 5 times in our opening brief, we said that the predominance inquiry needs to be conducted first, and it needs to be satisfied with respect to at least a cause of action, not the entire action if you have multiple claims like you do here. And then C4 can be used to do that pruning. I know that.
Sorry, Judge Rogers, did you have a question?
Yes, I did. Following up on Judge Child's points in her questions, and given our standard of review, in light of district court discretion, is your position inimical to a remand on the issues basically you raised, but also were this court to find that the reasons given by the district court do not withstand scrutiny? In other words, a lot of your answers, both to Judge Millett and Judge Childs, it seems to me, were arguing that the district court misunderstood the issue he was pruning out as being simple. Are you this or are you that? And if you're not, the case is over. What I hear you saying in some of your answers is there's a lot more to be done. And so judicial economy here is fanciful. And if that's the main reason the district court did what it did, then we would send it back for the district court to reconsider. Not necessarily by defining a rule of our own, but simply indicating that the district court has to give this another look in light of some of the limitations that the questions have identified through your answers.
Okay. I think I hear you asking Judge Rogers if we are amenable to a remand in the event that we don't get a full-on reversal. I'm not trying to put words in your mouth.
I don't know why people have so much trouble with my questions, all right? But I am asking that. The
Okay.
alternative here to our adopting a rule would be to send it back to the district court, leaving open the possibility that it could identify rationales for proceeding as it has suggested, but the rationales that it has offered are inadequate.
Yes, I understand, Judge Rogers. And so, our primary position is that, Castano, the Fifth Circuit case, articulated the rule probably the better than I did today. So, Judge Millett, if you want to look to that, that's where I'd point to. But as to your question, Judge Rogers, I know you were on our Rule 23F panel, and what we told you in a 28J letter then was that, even if this court were to, I don't want to say adopt, follow the guidance of the Third Circuit's Russell case, which has a 9-factor squishy test from the ALI that gives the district courts broad discretion. And we pointed out that even under that test, we would win this appeal because this court would have to vacate Judge Mehta's order. And I stand by what I wrote in that letter. So absolutely, if this court is unwilling to chart a hard path on what C4 means and disavow the notion of a issues class, then at minimum, vacator and remand would be appropriate. And I know I'm aware of my time, and I haven't even touched the FLSA issue here. And so, the court's indulgence, I'd like to quickly pivot to it, unless
I'm being rude again. I apologize.
No.
So you said you like the articulation from the Fifth Circuit, but I don't know how one gets out of that articulation that you can sever out things like affirmative defenses, reliance. That seems to me a much more wooden rule than what I'm hearing you articulate today, which seems to be sort of more nuanced, which can be nuanced and still have important substance, so don't misinterpret me. But that one seems to me a bit of a meat cleaver to build on Judge Posner's language as opposed to anything surgical.
So the Fifth Circuit actually was the reliance example I was giving you, where what the Fifth Circuit said you could do, this is a fraud claim involving tobacco. The Fifth Circuit said the reliance issues predominated over the other issues in the case. And then it said, you can't carve out the reliance issues and certify under 23C4 based on the complexion of the case in total. I think that this court could adopt what the Fifth Circuit did there and be consistent with what I've been saying this morning. That there are, again, certain recognized...
The recognized is really hard. I'm sorry on that, really. That makes it easy. We can say that's okay, but that doesn't tell district courts. It's really unfair to district courts because we don't say what other things are recognized until someone recognizes them and people say that's okay.
Then I guess this court would review whether the district court was correct in
well, and someone will say, well, it hasn't happened before, so it's not recognized. But it could be perfectly sensible and fit fully within the rationales that you're advancing.
I understand.
All right, did you want to, we'll give you a couple of minutes on the FLSA issue?
Yes, thank you. So what I was saying at the outset about the district court's order being unlike anything that circuit court has upheld before is even more true with respect to the FLSA. So with respect to 23C4, the district court at least purported to have the cover of the majority of circuits that have interpreted C4. With the FLSA, the district court adopted the minority view, and in fact went even further. One common thread that runs through all of the cases on both sides of the divide, and regardless of test applied by the various circuit courts that have interpreted what similarly situated means, the common thread there is that in each one of those cases, there are allegations of a common FLSA violating practice or policy. We don't have that, and that's undisputed. The plaintiffs originally alleged that in their complaint. There was discovery, and the discovery proved that to be false, and Judge Mehta himself found that those allegations didn't withstand scrutiny, and that is what led to him to reject a B3 damages class for lack of predominance. So to go ahead and fail to decertify, right, because the FLSA is different, that there's conditional certification, to fail to decertify an FLSA collective where there is no common FLSA violating policy or practice, and do so on the basis of, again, this one similarity, not a host of similarities. It's just contrary to what every other court, court of appeals in this country has countenanced.
Can I just ask you a procedural question? Sure. The district court denied certification under 1292B for this issue. In deciding whether to exercise pendant jurisdiction, would we first need to ask whether we thought the district court abused its discretion in denying certification under 1292B? Is that part of what we think about in doing this? Or do we just say, thanks for playing district court judge, we're plowing straight ahead on our own?
I would say the latter, Your Honor. And I mean, even though Gilda Marks recognizes...
Then what's the point?
Well, I think it's to give the district court the chance of saving this.
To say yes, but if it says no, we'll all ignore it?
It's to give the district court the chance in the first instance to save this court from doing the work. I mean, and that's, what you've articulated, whether a party has...
That's not usually how it works. Actually, that's why those things are generally reviewed under discretionary standards, is that we actually put the first call. It's not that we're like, we're too busy, you go do it. They're pretty busy in the district court too.
Absolutely.
It's that they're the closest to the litigation, yes, and they have the best vantage point, and they're smart and learned and can bring their best judgment to bear, and we don't lightly, in other circumstances, brush that off. So I'm just a little surprised that we would just pay no heed to it in this context.
Well, I mean, it is one of the Gilda Marks, the 8 Gilda Marks factors, whether a party has attempted to circumvent 1292.
Well, you haven't done that.
Right. We didn't do that. Went to Judge Metropolitan.
You're trying to circumvent the result of your 1292B application.
Correct. No, I mean, I guess if the district court in denying 1292B had said certain things that were relevant to the Gilda Marks factors, I mean, it'd be hard for me to tell this court to just ignore them. But as far as the legal tests for pen and appellate jurisdiction vis-a-vis a 1292B certification, they are different tests. This court has plenary jurisdiction as guided by Swint and Gilda Marks to decide whether to exercise pen and appellate jurisdiction. And as we laid out in our brief, at least 5, if not 6 of the Gilda Marks factors favor us here. And when you add to that the uniqueness of this case, where unlike the Second Circuit case, I forget, perhaps it was the 4th, plaintiffs cited 2 out-of-circuit cases where there was a Rule 23 ruling and an FLSA ruling, and those circuits denied pen and appellate jurisdiction, declined to exercise it. What sets this case apart and makes it unique, and I think makes pen and appellate jurisdiction to reach the FLSA issue easy, is that Judge Mehta expressly tied them together. And so it would be...
Well, not on the merits.
But should they have been interwoven?
Go ahead.
But should they have been interwoven like that?
Should they have been? Mm-hmm. I do think they rise or fall together as a practical matter, but the standards are different. Mm-hmm. And he didn't engage in a separate analysis as to both or explain how, even though they're different, I'm getting to the same place. He literally said, the question and the answer, it's the same for both. And so given that he did
said it's to the economy of litigation.
Right.
That's what he said it to. It's certainly not the same legal answer or even the same legal analysis. That's why you spent the same number of pages on that merits issue as you did on the merits issue under 23F. If it were the same analysis, it would have been what we said on the previous pages.
No, that's right. But I mean, because the tests are different. Rule 23 is a little bit more demanding, but at least in this case, when we believe that he erred and committed the same error that they did with C4, and he expressly tied his 2 analyses together without specifically accounting for whatever differences there may be, I think that's kind of, the extent this court needs a plus factor to push it over the edge in exercising pen and appellate jurisdiction, that's a unique plus factor that's absent from other cases.
We've kept you up a very long time. Thank you.
No, thank you.
Do my colleagues have, Judge Rogers or Judge Giles, have any more questions? Do you have any questions, Judge Rogers?
No, Judge Millett.
Okay. All right. Thank you very much for your time. We'll give you some time for rebuttal.
Good morning. May it please the court. I'm Michael Kirkpatrick. I represent the plaintiffs' appellees. Plaintiffs' claims under DC law require that they establish that MTM is a joint employer or a general contractor, and those issues will be determined based on evidence that is common to the class, as opposed to individualized facts regarding MTM's relationships with specific plaintiffs. So the district court was correct to certify those issues for class treatment under 23C4, and the decision below should be affirmed. Otherwise, those same issues will have to be litigated over and over again on behalf of potentially hundreds of individual plaintiffs.
I don't think I quite understand that answer. Because this is one action here in court here. You said the evidence is common, which there isn't, and MTM hasn't, doesn't think that it needs an individualized determination as to each service provider, whatever that acronym is, the service providers. That'll be, it's up or down. Either we're a joint employer across the board or we're not. Either we're a contractor across the board or we're not. And if it's common evidence, then help me understand what judicial economy has accomplished by not just having summary judgment, or a district court could order, partial summary judgment focused on just this issue in the very same action. But what would have gone different in this case if the district court had said, look, first things first, let's do whatever discovery you need and briefing on these two questions, and we'll resolve that on summary judgment first, and then we'll get to everything else.
Well, I think that the case would not have the class character then. I think the court had to certify the action for class treatment with respect to these issues in order to have it have binding effect in both directions versus seriatim litigation.
Well, they have already said up front and on the record that it's going to be one answer for everybody. And so they're on the record before the court, and the court could incorporate that into any decision. And I think that would be, quite useful in preventing having to relitigate this issue all over the place. And I assume you're talking about other actions, not this one, elsewhere in the court system?
Well,
or just as to this one?
What we have right now is the statute of limitations has been told for all of the putative class members and all the people in the collective. Once this issue is decided, then they will have to come into the action individually to prove up liability and damages. But if we don't treat it as a class action and we just decide this issue on behalf of the three named plaintiffs, well, then we're going to need to tell everybody who's been relying on American pipe tolling to keep those claims alive, and they're entitled to sit back and wait and see what happens. We're going to need to tell them they need to come in and file an individual action.
So that's the only judicial economy accomplished by this class action, is the tolling of the statute of limitations?
Well, we don't.
Because it doesn't sound like it's actual litigation economy. So it's just the tolling of the statute of limitations before people have to come in.
That's a major part of it. I think there's still some other economies and efficiencies here.
It hardly seems like that's what C4 is about. So tell me about the others.
Well, the individuals.
The other economies, I'm sorry, I wasn't clear.
Yes. If this issue has to be relitigated because it's only decided with respect to the named plaintiffs, if plaintiffs prevail, then yes, the others could probably rely on offensive, non-mutual collateral estoppel and get the benefits of that. But if the three named plaintiffs lost on this issue, well, others could still come in who would have their statute of limitations told, bring their own case and say, well, we want to try again. We're going to try to take different discovery.
Well, that sounds like a good thing for those plaintiffs not to be bound, and it's MTM is the one that doesn't want the class, so they're going to be stuck with the consequences of not having one and have to litigate this all over town. Right,
and overall fairness of the class resolution, I think it actually favors defendants because it binds both ways.
Well, I guess they get to be the expert on what favors them.
But that is the main efficiency here, is to decide a threshold issue without having the possibility of hundreds of people needing to come in individually before that issue is decided, or waiting, in the wings.
Have you thought of other cases, perhaps in other jurisdictions, in which you have a collective action, but it doesn't ultimately resolve liability. Like, in other words, the collective action has been certified, but it hadn't resolved liability.
No, I am not aware of any such cases, but I do think that this case does fit within the Scott and Campbell articulation of members of a collective are similarly situated when resolution of a common issue will materially advance the resolution of the case. And I think there's an important practical thing to keep in mind, which is why I don't think we really need to get to the FLSA issue, is everybody in the FLSA collective is in the class. And the class claims, which are under DC law, are better than the FLSA. They provide more robust relief, and they provide an alternative pathway to joint and several liability, which is this general contractor rule, which is in DC law, but not under the FLSA.
So could you get the tolling just by virtue of the FLSA collective action?
No. Only with respect to the 150 individuals who opted in. But those 150 individuals are in the class.
Yeah.
And either way, if they need to come in after a decision in plaintiff's favor on joint employer and general contractor, or come in because, the named plaintiff's lost if the certification is reversed, they're going to come in because that's where they get the more robust relief under the DC law and the two alternative pathways to holding MTM jointly and severally liable. So the fact that these 150 people opted into the FLSA collective, they certainly, once given notice that they need to come in if they want to prove up liability and damages under the DC law, they're going to do that.
Can you have a collective class be similarly situated, but then still lack commonality?
Well, they don't lack commonality with respect to the question of whether MTM is a joint employer. And because that is a threshold question here, I think it makes a lot of sense to move forward and decide that question as part of the C4. And this is sort of an unusual circumstance because, when you think about it, there are a lot of meaningful issues that involve multiple questions of law or fact, and factual differences among class members might make those issues turn on individual questions that predominate over common ones. But here, MTM's practices were the same across all the subcontractors insofar as those practices are material to joint employer and general contractor. And that's not always going to be the case, even when joint employer is at issue. So this is, in some ways, an unusual situation that they treated everybody the same in terms of the way they dictated terms for hiring and training and performance of the drivers. It's the same with all of the transportation providers. You can easily imagine a situation where somebody who's at the top of the pyramid like MTM has very different relationships with transportation service providers. We don't have that. But if I could just
Which is why it could be resolved on summary judgment.
Yes, and I want to just
without
take up
being a class.
Well, I want to take up the text, and that gets to your question, because I think this is really important. Rule 23B states the conditions under which the class action may be maintained. And 23C4 provides that an action may be maintained as a class action with respect to particular issues. So if you read those two provisions together, the most sensible construction is that the 23B conditions on maintaining a class action need only be satisfied to the extent that the class is so maintained. That is, it is only the certified class action that has to satisfy Rule 23B, not any part of a case that isn't a class action. And that, I think, is really important because earlier the discussion when my friend was up here about B3 and having individualized issues of damages, those cases, they were certified under B3. They were not certified under C4. We're talking about cases like Tyson's Food. Under their construction, C4 does no work. It's completely superfluous. And it should be interpreted to have meaning to do some work. And what it does is it does the work where we still have to satisfy for the certified issues all 4 of the 23A requirements, and we still have to satisfy 23B3 predominance and seniority with respect to the issue certified, and we have to show that it's appropriate to give this class treatment. So there's about 7 things that we have to show here.
Where did
and
the
that's what
district
court
court,
found.
where did the district court make findings on those 7 things in its decision?
The court in
And
the
particularly with respect to commonality.
well, yes, you have to look at when we originally moved, we moved for B3 and asked for C4 in the alternative. The court had a decision where it walked through each of the 23A requirements and said that they were satisfied. And then it said superiority is satisfied. And then it said, but predominance is not satisfied as to the claim as a whole, and gave us a chance to come back and further brief the propriety of C4. That was a supplemental brief. And so then the court decided, yes, C4 is appropriate with respect to 2 issues, joint employer and general contractor. And so the court was incorporating.
Where did the district court find predominance?
With respect to the certified issues?
Yeah, in its supplemental class certification.
The court discussed, and this is it's page 15 of the decision, it's 2391 of the joint appendix, talking about the different, schools of thought on C4.
Sure, that's sort of its general background. It's not its analysis section. Its
Right.
analysis section is where would be where the rubber meets the road in this case.
Yeah. Well, on page 19, 2395 there, it says ultimately the question is the same.
Materially advanced litigation, that's not the same as predominance, is it? I'm no class, you all are all much more experienced in class actions than I am, but that doesn't sound like predominance to me.
Yeah, Judge Millett, I'm having trouble.
Okay. If you find something later, you can.
Finding it.
Okay.
But I think, the fact that the court discussed the need, broadly to show predominance with respect to the issues, and then said, you've shown what you need to show in order for me to certify the C4 class here.
It's implicit in its analysis.
It's implicit. Okay. And then,
the baseline, sorry, finish your sentence.
The court talked about, is it appropriate, and sort of used this formulation of, well, will it materially advance resolution of the case?
So that answers the appropriate question, not the predominance question.
That's right. The court also discussed superiority, which we also have to show, saying this is superior to the alternative of litigating it over and over again in potentially hundreds of cases.
Did it appropriately flesh out the commonality? I didn't hear you answer that one.
Well, commonality, it was in the original decision where he went through the 23A factors, and so he discussed commonality there.
I thought you said the baseline changes when we get to C4. When he was doing that original analysis, the baseline was as to, and now you'll correct me, either the whole cause of action or the whole litigation, was it?
Well, it would only be with respect to the DC law claim.
Right.
So
the
those
causes of action was the baseline. But you tell me the baseline changes under C4. You don't. Otherwise, it wouldn't accomplish anything. You'd have the same problems one with the other. So what is the baseline? So the baseline for 23A and B3 shifts under C4, I think, under your theory.
I think only with regard to B3.
Okay.
I think with 23A, those are requirements, and they're frankly not that hard to show under this kind of case. And so the 23A requirements are going to be the same. And then when you get to B3, the requirements are still the same. You have to show predominance and superiority, but only as to the issues certified.
No, but there has to be, when you ask about predominance, you can't be predominant in the abstract. You have to be predominant as to what? And we know in...
The issue certified.
Well, how can you be predominant as to the issue certified? Because the whole rationale for the district court plucking the issue out, or you all proposing the issue is, well, at least as to this one, it's all consistent. And so it seems to me it's going to be pretty much an empty analysis to say, okay, let's sever out this thing that everyone says is common evidence, and we march through the 23A factors again, and all those are met. And so joint employer is a predominant question as to joint employer? I just don't know how, again, for like I was asking your friend on the other side for writing an opinion, I just don't even know how to articulate that. I think I'll get laughed at if I were to write something like that, or we were to write something like that.
Yes, we still have to show predominance, but certainly the more narrow the issue becomes, the easier it's going to be for us to show predominance. But we still have to show superiority, and we still have to show that it's appropriate. And if we talk about, well, if we keep stripping things down to the most basic question, you're always going to be able to show predominance. Well, that may be true, but if that question becomes, too basic, we've drilled down to something very, very basic, then maintaining a class action is not going to be superior, and it's not going to be appropriate.
Well, what if, joint employer is sort of a multi-factor test. So what if as to, and I forget there isn't even consistency on what the precise number are, but let's just assume there's 5 factors for purposes of this question. Could you have a C4 class that says as to 3 of those 5 factors on joint employer, those commonality, they'll be proven by single evidence, just like you have the same evidence. Can they carve it up one layer more than they've done here?
No, and I don't think it really works with respect to the joint employer analysis, because even one factor can establish joint employer if it's overwhelming. Yeah, but
you got to look at all the factors.
Yeah, joint employer, you can't really divide it up that way. It wouldn't make sense to do that, and it wouldn't be superior or appropriate to say, I'm only going to concentrate on, for example, who paid the drivers, which is one element of the joint employer analysis. It's not required, but it is something that's indicia. It wouldn't make any sense to do that because you've drilled down to such a low level that it's not really doing any work. And that's the thing to keep in mind.
It's much more efficient to answer 3 of those questions all at once for everybody than to have them all litigated separately. I don't understand why that's any different than breaking out joint employer and the rest of it. You've already separated liability into joint employer / general contractor and everything else. And so I don't understand why you can't subdivide.
Well, I don't think it does it very much to subdivide factors that are not determinative. It's the factors taken as a whole.
So if we had a different legal question for which there are 5 tests to satisfy it, each one of which could be an independent basis for liability, then it would be okay to certify on 3 of them, but not 2 of them?
If the court thought it was superior
You'd have to go through the other factors.
Then yes. But the district court would have to make those determinations. And think about how rare C4 certifications are. I mean, we've had C4 now for 56 years? There's not that many C4 cases out there, because usually if you do drill down to such a tiny sliver of the case, yes, you might be able to show predominance, but it's not going to be superior to the alternative.
They're always going to be able to say it's more efficient. They'll be able to say it's much more efficient to just do this once than to litigate it 800 times. When it's going to be the same evidence, it's going to be the same up or down answer.
Right.
So you're going to have predominance, because we'll go, well, does it predominate as to this sub question? Yes, it does. And it's going to be, I think it's going to be easy to find superiority, because this poor district court struggling with this massive case is going to say this is much easier than doing it 800 times. And it's appropriate because when it's superior and predominant, in this case, it just makes sense for efficiency and consistency in resolution. What's wrong with that analysis by a district court?
I have to push back on the appropriate element, because appropriate means it will materially advance the resolution of the case. And if it's too small a subpart of a factor, it will not materially advance.
C4, when appropriate, looks at the entire case, not the issue?
Yes. will it materially advance resolution of the case? And here it will.
It wouldn't be faster to do it as a class than to do it 800 times over?
Yes,
I
and
would
that's
think-
why C4 makes sense.
No, but I mean, under my well, it's going to go faster once than repeatedly.
Yes.
Okay, so
Yes.
then that would be an appropriate C4 class.
Well, but again, we have to look at everything else that's going to have to be determined.
I've
And-
already marched through how those are going to be analyzed.
Okay.
We're going to, the 23A stuff is going to carry through. Predominance, because we only ask it as to those three questions, and superiority, because it's much more efficient. It seems to me to be large, certainly efficient for resolution of those issues.
Yes.
And it's consistent for both parties, up or down, one way or the other. It could let someone out of the litigation altogether. And it's appropriate because anything I can clean up in this case quickly, consistently, and in one fell swoop will speed this litigation along.
And that's
Alex, we
further-
probably didn't let you even make your own points. Do you guys have more questions? Any questions?
I don't.
Judge Rogers?
No.
Okay. Did you want to touch briefly on FLSA?
Sure. Yeah, I think I've covered, our arguments under C4. On the FLSA issue, again, there's no reason to reach it here. We take a step back to pen and appellate jurisdiction, because as I explained, everybody in the collective is in the class, and they're all going to come into the class if there's an opportunity to do that, and the same is going to be determined because the DC law, which is the class action, completely covers the FELICIT claims, gives better relief, and gives this alternative pathway to joint and several liability. So there's just no reason to get to the FLSA issue. But if we do, we think that Scott and Campbell are the best approach. And basically what they said is you can have similarly situated members of a collective where there's a common issue that, again, sort of materially advances the resolution of the case. It is true that typically those are policies or practices that are FLSA violating, but it doesn't have to be. And that's what we think the district court made the correct decision here, saying, yes, they're similarly situated because the joint employer question is going to be resolved the same way for all of them. And so we do think that, if you reach that issue, we prevail, and Scott and Campbell is the best test. But there's really, as a practical matter, no need to reach it because this is all going to rise or fall on the C4 class action.
My colleagues have no questions, and thank you very much. And Mr. Andre, we'll give you 3 minutes.
Thank you, Judge Millett. I guess I wanted to push back on one thing that Mr. Kirkpatrick said about the potential binding effect of proceedings that the district court has contemplated here. And this is critical in our view. The district court, this is at page Joint Appendix 2454, the district court has said he is not going to issue notice to the putative class members. So there are 800 that have been identified, at least by number, by the plaintiffs. But I don't know how they come into this case because they're not getting notice and being told to come in.
The district court said that as a C4, that there's not going to be any issue of notice?
Correct. And so that further, I guess, undermines not only the integrity of the district court's ruling, but it opens the door to all the problems that the carefully reticulated Rule 23 scheme is designed to address. That you have to give notice, that the judgment has to have sufficient clarity, the appointment of counsel, and so on and so forth. And so, the fact that there is not class notice going out to these 645 other drivers, and I guess we're going to get technical, the notice that the opt-ins got was just as to the weaker or less valuable FLSA claims, and so they didn't get technical notice that this other DC state law claim is pending. And so that doesn't protect their rights. And that's one of the concerns that animates whether a classification order should be upheld. And it doesn't protect our rights because we basically have an advisory opinion, which again goes back to why at the outset I'm still struggling to figure out why this wasn't done under a partial summary judgment motion with just the named parties. I guess I also wanted to push back on the suggestion that under our hypothesis, C4 does no work. The Deepwater Horizon case, which both amici and plaintiffs assert is kind of the final nail in the coffin of Castano. If you read that case carefully, it doesn't mention Castano, and it actually is doing precisely the work that I've been explaining that C4 was kind of designed at its core to do. It's doing what the advisory committee said back in 1966 it should do. Deepwater Horizon severed off damages, and then in doing so, the Fifth Circuit said, and C4 is what allows us to do that. And so that's all we're asking for. And so, again, our position is not going to render C4 a nullity.
Where did the district court say it wouldn't do notice under the C4 class?
Joint Appendix page 2454.
2454.
2454. I guess with my last 2 seconds, I'd say Mr. Kirkpatrick said that predominance is applied to the issues certified. And we think as a textual matter that is contrary to the rule. B3 speaks in terms of the controversy, which I think has to certainly mean more than issues certified. It has to mean at minimum a cause of action, kind of a full controversy within the broader controversy, but not something as small and as preliminary as whether my client is a joint employer or a general contractor.
Can you respond to Judge Millett's earlier questions about why not partial summary judgment, and then whether or not you offered any such alternative options?
I don't want to misspeak. I don't believe we did. I don't believe we did. Or,
okay.
But I don't know for certain.
Okay.
Very cool. Any Judge Rogers or Judge Childs, any further questions?
No.
All right. Thank you very much.
Thank you, Your
both of you for your time. The case is submitted.
Case number 22-1714, Metropolitan Washington Chapter, Associated Builders and Contractors, Inc., Appellants, Miller and Long Concrete Construction, Inc., and Emmett Morris Jr. versus District of Columbia, a municipal corporation, and Muriel Bowser in her official capacity as mayor of the District of Columbia. Mr. Kiernan for the appellants, Mr. Phillips for the appellees.
Hey, police support. Judge Edwards used to tell his Georgetown law students half facetiously, the only thing appellate courts care about is the case properly before us and what's the standard of review. I'm going to address both of those points because I know that's what's on the court's mind. But I don't want to lose sight of the bigger picture, which is that the decision appeals from confirms or affirms the proposition that in creating a municipal government in the District of Columbia, Congress intended that government have the unreviewable authority to enact economic protectionist legislation that no other state or city in the United States would have the constitutional authority.
What do you mean unreviewable? It's reviewable by Congress and it's reviewable by courts.
Well,
I mean, it's automatically reviewable by Congress. You don't dispute that.
The Congress always has the authority to legislate for the district.
Sure. So it's reviewable by Congress.
Well, but Congress has not acted on this issue. I don't
Okay,
think
but that doesn't mean it's
constitutes-
unreviewable. It just means Congress chose not to intervene.
well, Congress chose not to act. I agree on that.
Okay.
Okay.
And
So-
the courts can review, and here we are reviewing, and the question is simply, just because you can get reviewed doesn't mean someone wins on the merits of any claim they bring.
Understood.
Okay.
My point is that this type of economic protectionist legislation has routinely been struck down all over the country under constitutional provision. The lower court said that neither the Privileges and Immunities Clause nor the Due Process Clause affords an avenue to review it, even though privileges and immunities would apply everywhere else in the country. And due process, the court said, that's never been done before. It reminds me of the case you just heard. It's never been done before, and therefore we're not going to. And it all comes back to, obviously, this court's decision and the Duhay decision, and the Duhay case back in the 30s, which the court said that when Congress legislates for the District of Columbia, it is not subject to the Privileges and Immunities Clause, a proposition with which we do not disagree. The question is, as I understand the argument made by the district, is whether somehow that immunity from the application of, let me use a different phrase, that exclusion from the Privileges and Immunities Scope has somehow traveled through to the City Council of the District of Columbia. And that was done intentionally by Congress through the Home Rule Act in order to, in some sense, make up for the fact that Congress otherwise limited the council's authority, for example, to enact a commuter tax, to affect the jurisdiction of local courts, et cetera.
What's your argument with respect to standing, though? I mean, you've got Metro Washington as a corporation here that generally does not apply to the Privilege and Immunity Clause.
So we are here, Metropolitan Washington is the remaining party in this case. We are here through associational standing. We met that in the Hunt test below, essentially not really disputed, because this issue is germane to the work of our organization. It is an issue in which we have been involved in lobbying and in the concern of our members and their employees for many years. We've litigated this issue elsewhere. Other chapters have litigated this issue elsewhere in the country.
But is that standing distinct from Privileges and Immunities versus Commerce Clause?
The issue, I think, Your Honor, on the Privileges and Immunities analysis is Privileges and Immunities reflects both an individual right of a person, but it's also a structural limitation on the power of government. Our members and their employees are the vehicles through which the council is, in which the law is acting to discriminate against non-residents. In other words, we're the ones that have to comply with the law and who suffer the penalties if not complied with. And we have to do that to our employees. So I think the Privileges and Immunities analysis, while the employees may have their own separate claim, which the district court below found for these individuals did not approve out. But while individuals may have that claim, I don't think that diminishes the right of the organization, the association, I should say, to speak to the issue of the Privileges and Immunities, because they are the ones who are actually directly impacted and have to modify their conduct and suffer penalties.
But Metro is a corporation.
Metro is, well, it's a chapter of a larger organization. It's an association of a number of companies, sole proprietorships, and others who are members of this trade organization. But Metro Washington is a chapter of a larger.
But they're all your members are businesses that are not protected by the Privilege and Immunities Clause.
But our employees are, and more important.
Are you a trade association of those employees?
I'm sorry?
Are you a trade association that purports to represent those employees?
We don't separately represent the employees.
No,
we are working with the companies.
The companies.
With employees, and it's the companies.
To have standing, the Hunt standing, that you're the associational standing, on the grounds of the employees, your members would have to be the employees. And you would have to show that the interests you advance are those of employees. And that can be very distinct from the businesses that employ them.
But I think in this case, Your Honor, the associational, because the statute acts against the employers who are required to then take the steps that we say are unconstitutional as to our employees, We're the vehicle through which this is implemented. Our members do not want to do this. They're the ones who suffer.
No, I understand, but they're not protected by that they can bring the Dormant Commerce Clause challenge, but those members may feel very much injured. And I don't think anyone has quibbled with those assertions in this case, but they simply aren't protected by the Privileges and Immunities Clause. And I haven't heard you dispute that substantive point about the scope of the Privileges and Immunities Clause.
What I'm disputing, Your Honor, is that it's limited to that the Privileges and Immunities Clause is limited in its application to the individual right of an employee, as opposed to it is also a structural limitation on the power of government to enact legislation.
Well, of course it is. I mean, like the Constitution is filled with structural limitations, but that doesn't mean everyone can enforce them. Not everyone is persons for purposes of other constitutional provisions either. Sometimes they are, sometimes they aren't. Depends on the provision. But for this one, I thought it was recognized in the law that businesses are not protected by it.
Businesses, as I understand the law, a business, a corporation, does not, under current precedent, have its own privileges and immunities claim as against the government. It doesn't, a business does not have the right to travel, for example, right? It doesn't have that kind of, but this is a different situation in which the residential preference is being implemented by directly acting on those employees in a way that is unconstitutional under either the Privileges and Immunities Clause or as applied to the due process. Second point is our employers, our members, are not that distinct from their employees. They have to deal with the employee on assignments, on bidding.
Of course, and of course that's how the employer-employee relationship works. But to be, you never claimed in the district court, and I've seen no affidavits from employees, saying that we have this injury, just like we commonly require for associations elsewhere to establish standing. I see nothing here in this record that says that you purport to be an association of employees as opposed to of employers.
Well, we have.
I mean, you're not an association of employees. You're an association of employers who necessarily have employees. Is that your point?
My point was we have sole proprietorships in our organization. We have the employees should be considered for these purposes as part and parcel of whom we represent. I think that's appropriate, and I think the record was clear that that's what the standing was below, and it was upheld with below. The only change now, I think.
Well, there were employees present in the litigation below. There are here. Oh, go ahead.
Was whether the fact that the other parties didn't have the stamina, if you will, to continue with the case somehow now deprives us of that standing that we had below. And I think under the court's decisions, when an entity appears with associational standing, it's not required that the member also be in the lawsuit or on the appeal, which is what we have here.
Okay.
The district has also raised the issue of prudential standing, which I think dovetails a little bit with the issue the court's raising, which is, are we asserting the rights of parties that are not before the court? The answer to that is no, we're not. This is the same claim we have asserted from the outset.
To clarify one other thing, I'm trying to understand, because we have that Duhay decision from our court. And as I understand it, your argument is that the Home Rule Act changed things, made the district subject to the Privileges and Immunities Clause. Is that right? As a matter of federal legislation.
As a matter of federal legislation, the municipal government set up by Congress should be limited in its powers by the Privileges and Immunities Clause or incorporating the rights or incorporating
whichever way you want
the process, whichever way.
Right, and you say they should be. I thought you said that, I thought your argument was not that they should be, wasn't normative, but that in fact, the consequences of the Home Rule Act was to subject the district to the Privileges and Immunities Clause.
I think that's correct. I think that's correct. When the clarify, when the district is acting on its own behalf,
Sure,
not Congress.
sure.
Congress not touching.
But didn't Congress explicitly include the privileges and immunities clause in the organic acts of, for example, Puerto Rico, Guam, et cetera, but not the Home Rule Act?
It did. It did. But I don't think, Your Honor, that that means that they meant to create in the city council a power greater than any other legislature has. And part of the reason I say that is because of the legislative history of the Home Rule Act, in which much attention was paid to how are we going to limit the scope and power of this new government and to a commuter tax and affect the jurisdiction of the courts. Great attention paid. And it seems to me that the idea that silently Congress intended to invest the District of Columbia Council with more authority constitutionally than any state legislature in the country just doesn't make sense. I agree. The act does not call it out specifically. And as the district pointed out in its brief, and as we argued below with the judge, there is no specific reference to privileged immunities either way in the Home Rule. But I think that the district's position is that's because privileged immunities doesn't limit the power of the municipal government, and the citizens of the District of Columbia are not entitled to the protections of the Privileged Immunities Clause, presumably when they go elsewhere. I think that's an untenable position in this day and age, because it's
So
just.
your position is that Congress said in the Home Rule Act that unless we specifically enact a limitation, the city council has plenary authority unless Congress, during the oversight period, disapproves of one of its enactments or otherwise enacts legislation as a federal legislature, changing something that would affect the abilities of the local government under the Privileges and Immunities Act.
Yes, Judge Roger, that's our position. Yes.
All right.
Congress at any time can legislate whether there's an act pending by the council or not pending or during the review period. It can do whatever it wants. And that's not the issue in this case. I think what is an issue in the case is should the fact that Congress has chosen not to legislate be deemed an endorsement or some sort of congressional action? That there's no precedent that I could find, and I'm sure if the district had found it, it would have cited it to the court, in which a court has said that because Congress didn't act on it, didn't make its own act, that somehow it therefore endorses or adopts it as if it were a congressional action.
There are two aspects to it. One, it didn't act during the congressional review period, which is unique to the District of Columbia under the Home Rule Act. And it also didn't take other action that would address whether the District of Columbia was subject to the Privileges and Immunities Clause.
Yes, Your Honor, it's both prongs of that, yes. I agree.
So in that silence, the court has no option other than to conclude that the council had this authority and now is subject essentially as would a corporation in a state.
I think that's correct, Your Honor. The position that we would take is that once the new government is stood up as an independent legislative body, subject always to Congress's plenary power to legislate for the district, that it should be subject to the same limitations as every other government in the country regarding its ability to enact this kind of residential preference law. And that Congress's decision not to act in this area should not be, and I can't find a precedent for therefore being Congress itself is now acting And since Congress isn't subject to privileges and immunities, therefore, this action by the city council shouldn't be subject to the same. I notice my time is
Do you
up.
know, Judge Rogers, did you have more follow-up questions?
I think I've taken up enough time.
Do you know if privileges and immunity clause applies to Indian tribes?
I don't know the answer. I've not looked.
And then I want to just understand your theory. So the Home Rule Act, the structure you've been discussing with Judge Rogers, in your view, Congress can't pass a law that rewrites the Constitution, right? That's
Right.
common ground. And so the effect of, if the Home Rule Act is read the way you propose, as then really what it says is, as a federal statutory matter, you apply that same protection and legal tests to actions of the District of Columbia as a matter of federal statutory law. This federal statute requires the district to color within the lines of the privileges and immunities laws.
I agree with that. And to just clarify, maybe to push it a little bit, it does not mean that acts of the District of Columbia government become congressional statutes just because Congress set up a municipal government and retained, obviously, its constitutional right
Sure.
to act in a plenary fashion.
I
And
think that, yeah.
Yes, so no, I'm trying to make a different point, and that is when Congress passes a statute like it did in the child's reference in the Organic Acts for Alaska, Virgin Islands, and Guam. It can't rewrite the Constitution just by passing a law. So what it does is, by a statute, say jurisdiction will be subject to the same obligations as a state is under the Constitution's Privileges and Immunities Clause. And courts, you'll apply the same legal analysis and same legal test. But it is, and if the district fails to color within those lines, is exceeded its authority under the Home Rule Act, much like a federal agency can exceed the authority delegated by Congress. The theory is Congress would have said, district, you can do A, B, C, and D, but you can't, under your theory, violate the Privileges and Immunities Clause in the process, and you can't violate Article 1, Section 10, and any other arguments that folks want to make about the scope. So if this statute if the Home Rule Act brought that protection in and they violated it, that would be a statutory violation, that they exceeded their authority under the Home Rule Act, correct?
Correct.
Have you made any statutory arguments in your case?
I don't know, Your Honor, no.
So you've only argued that the Privileges and Immunity Clause, in its own right, as part of the Constitution, prohibits the district from doing this, not that the Home Rule Act prohibits them from doing this.
That's correct. We have not made that argument.
The Congress couldn't have changed the content of the Privileges and Immunities Clause with the Home Rule Act. The Privileges and Immunities Clause has not changed, to my knowledge, has not been amended between Duhay and today. Okay.
How does the Commerce Clause, do you have any distinction in the arguments how it applies with respect to whether the district is expending its own funds versus not doing so?
On the Commerce Clause issue, Your Honor, as I think laid out in our papers, this is a situation in which the law applies to situations in which the district is not itself a contracting party. It is acting as a regulator. It is requiring, for purposes of its own regulations, drive income, tax revenue, et cetera, that private employers do these. And it's very distinct from the Boston case and others, where the government is actually using its money to go, contract for a building or something.
So you would read the papers to indicate that an as-applied challenge was put forward?
I'm sorry, Your Honor?
That an as-applied challenge was put forward?
Yes.
What's your as-applied challenge? What are the facts of your as-applied challenge?
No, I'm sorry, maybe I misunderstood the question, Your Honor, I'm sorry. We filed this as a facial challenge, basically at a pre-enforcement stage, just as the new law was coming into effect, because the new law increased substantially the requirements and the penalties. So when we started the case, it was essentially a pre-enforcement case.
Got it.
Because we knew this was coming, and then as the case unfolded over 10 years, we supplemented the record with instances in which the law was applied against companies, and we argued employees of the trial court.
One more quick question. You mentioned sole proprietorships in your membership. You're not arguing that the privileges and immunity clause does apply to sole proprietorships as sole proprietorships, are you?
No.
Okay.
What I don't know, Your Honor, check with the client, is whether we do have members who use the AKA, or not a technical corporate form, but an individual.
Sorry, the AKA?
Now, in other words, they are a business that's just themselves. They use a business name, but they're not actually a corporation. It's just that John Jones Plumbing.
Okay.
Just to be clear, back to the issue on as applied, you mentioned facial challenge, but I believe on the JA record, maybe 53, it does say as applied.
Is that in the original? That may be the original complaint, Your Honor, I think.
Okay.
Yeah.
But are you suggesting that there's only a facial attack?
I think that's really what the only thing we pursued.
Okay.
Yes.
Judge Rogers, do you have any more questions?
No, thank you.
All right, thank you very much. We'll give you a couple minutes for rebuttal.
Thank you.
Good morning, and may it please the court. Graham Phillips on behalf of the District of Columbia. As the Supreme Court observed shortly before the enactment of the Home Rule Act, unlike either the states or territories, the district is truly sui generis in our governmental structure. In many respects, that unique constitutional status operates to the detriment of the district and its citizens, most notably in denying them representation in Congress. But there are certain provisions of the Constitution that are limitations and restrictions explicitly framed as limitations and restrictions upon states, and thus do not apply to the district, unless Congress extends them to the district by statute. The Privileges and Immunities Clause is such a provision. It does not, of its own force, apply to the district because it applies to states, as this court has held. It has not been statutorily incorporated against the district, and it is not sort of indirectly applicable through the Fifth Amendment's due process clause. So if this court reaches the merits of Metro Washington's privileges and immunities argument, it should reject it. But I don't think this court should reach those merits because Metro Washington, which is the sole challenger here, lacks prudential standing to make a privileges and immunities argument. And it's that lack of prudential standing that I want to focus on first. And in particular, I'd like to push back against the notion that we forfeited this issue in any way. In our very first filing in the district court, in our motion to dismiss, we specifically argued that Metro Washington and its corporate members could not bring a privileges and immunities argument. And the district court agreed with us. In its motion to dismiss ruling at Joint Appendix 87, footnote 9, the district court wrote that Metro Washington and its corporate members, quote, do not have standing to challenge the First Source Act under the clause, end quote. And that was a ruling about prudential standing, even though the district court did not use the word prudential. And I think we know that because that ruling followed after a sort of lengthy explanation of why Metro Washington and its corporate members did have Article 3 standing to challenge this statute. And I just want to make clear that our argument here on appeal is not an Article 3 standing argument. It is a prudential standing argument. So that issue was both pressed and passed upon below. So I don't think there's any argument that we have forfeited it in any way. As a practical matter,
did you have an obligation to renew it at a summary judgment?
Oh, I don't think so. And I don't know why it would have made sense to do so because there remained individual plaintiffs throughout the entirety of the proceedings below. So the trial court had sort of already ruled as a matter of law correctly that the corporate entities could not make this type of argument. And then we still had to sort of address it because there were the individual plaintiffs. But so I'm not aware of any precedent that would say we had to renew that. And I don't think Metro Washington has argued that we needed to renew it in that way. So just on the sort of substance of the prudential standing, I think it's fairly straightforward. corporations do not have rights under the Privileges and Immunities Clause. That's settled precedent. And so the only way that Metro Washington can conceivably be here invoking the Privileges and Immunities Clause is if it's sort of implicitly invoking the rights of third parties, namely non-resident workers. But, you know, in their opening brief, they sort of, not sort of, explicitly said that they are not seeking to invoke the rights of anyone else. And I think my friend on the other side conceded that again here at the podium. So I think that's the end of the matter. If they're not trying to invoke someone else's rights, and they're truly only trying to invoke their own, they don't have any. And that's the end of the matter. But even if you sort of...
Well, they say they represent, by representing the businesses, they're necessarily also representing their employees who are burdened by this.
Yes, I think that's incorrect. I think they don't cite any authority for that proposition, I think because there is none. An employer and its employees are very much distinct legal entities that often have divergent or even actively adverse interests, and they're a different party. And an employer could try to invoke third-party standing for employees. We're not saying that they can never sort of obtain that type of third-party standing, but Metro Washington has not done so here. Again, they explicitly sort of disavowed this and have not grappled with the sort of well-settled law about how you show that you can have third-party standing. So I think even if they had sort of articulated that in the reply brief, it would have come too late, but it's not there either. So I think that can be the end of the court's analysis on the privileges and immunities issue.
And just to go back, if we agree with associational standing, does your prudential standing argument fail?
No, thank you for asking that, Your Honor. They're distinct, and so we're not disputing that Metro Washington has associational standing to sort of. I think practically what that lets them do is stand in the shoes of their particular members, the particular members that they have identified in this litigation, and they have identified some, but all of those are corporations. So associational standing sort of gets them down one level, but it gets them down to a level where the parties are still corporations who lack any privileges and immunities rights. So I don't think that helps. There was some brief mention here about that they may have members who are sole proprietors. I don't, I can't say that that's not true, but I don't think that matters either, sort of for two reasons. First, and most importantly, because no such sole proprietor has been identified in this litigation, and this court's case law about association standing says you do have to sort of specify who are the members of your association who suffered the requisite injury, in some form during the litigation, and no sole proprietor has been identified here. Just as a sort of secondary matter, again, that even setting aside the corporate form problem, the employers are not the ones being discriminated against on the basis of residency. This law treats all employers exactly the same, whether they're a District of Columbia employer or a Virginia employer. So even if we didn't have this sort of categorical bar as to corporations, which we do, they would still separately not have first party standing because of that additional problem.
Do you know if privileges and immunities applies to Indian tribes?
I don't, Your Honor. I had not considered that question before you asked it.
Okay.
The one
with respect to the privileges and I'm sorry.
No, that's
okay. Well, with respect to the privileges and immunity clause, does it matter if Congress passes legislation versus here the District of Columbia passing the legislation?
So when Congress acts, it unequivocally is not constrained by the privileges and immunity clause. Our position is that the District of Columbia Council is not either. It's not sort of directly by virtue of the Constitution because it's not a state, and Congress has not constrained it by statute to apply the privileges and immunities clause. We don't dispute that Congress could do that for the district in the way that it has done for other territories like Puerto Rico and Guam. But in point of fact, it has not done so for the district. And I'm happy to sort of delve further into that if the court has any questions. I guess maybe one thing I'll raise that conceivably could matter either for this issue or the Dormant Commerce Clause, Judge Childs, you raised a question about there is one reference in the complaint that says as applied, but there's no explanation in either in the complaint itself or in anything that subsequently happened sort of in what sense this case entails an as applied challenge. I think my friend on the other side has recognized that. We are only dealing with the facial challenge. And I think that would matter if this court were reaching the question of how the privileges and immunities substance plays out here. But I don't think the court should for either of our kind of arguments in parts 1 and 2 of our brief. But I also think it matters for the Dormant Commerce Clause issue because this act does very much apply in situations identical to those discussed in White. And we just gave 2 examples in our brief of the types of projects or contracts that really are the same exact thing as White. It is the District of Columbia spending its own money to purchase services for itself. And that's exactly what was said.
Is there any dispute in the record that at least some of the jobs that are covered by the First Source Act include sort of direct contracts between the district and companies to build something for the district?
I don't think there is. I don't think there can be. It just, I mean, I don't even think that's an issue of the record, Your Honor. I think it's just an issue of the meaning of the statute. I mean, I think just on its face, it applies.
Well, I was trying to say that on its face, but it would actually happen in practice as opposed, it would seem silly to think that that was just thrown in there for those purposes. But are there examples that you're aware of that are in the record or a matter of public knowledge about this?
Yes, Your Honor. So we discussed 2 examples in our brief. Let me see if I think it's pages 39 and 40 of our brief.
Yeah, I was just trying to make sure that there's no dispute about those, no disputed facts, or they're in the record, or.
Well, so I don't think they're in the record. I don't think those particular examples were raised at summary judgment, but the contracts themselves are publicly available through the contracting portal that we identified there. As are many others. I just thought these were sort of clear examples. And the reply brief does not sort of dispute that those are indeed contracts that sort of fit our description and are subject to the act. So I don't think there really can be such a dispute that it applies in those circumstances. And in that circumstance, it's indistinguishable from White and is therefore constitutional under the Commerce Clause for the same reasons.
Just curiously, is the peculiar evil just kind of not being able to tax the commuters or commuters taking jobs away from residents?
I think it's more the former, Your Honor. It's not, we have not argued that sort of non-residents are the cause of district unemployment. The problem that we have highlighted is that is the taxation issue. Yes. I'm happy to answer any further questions that the panel has, but if not, we'll rest on our briefs.
Judge Rogers, do you have any questions?
Thank you.
Okay. Thank you very much.
Thank you.
Mr. Kiernan, we'll give you 2 minutes.
Thank you. I have nothing further unless the court has.
Do you dispute the contracts referenced on page 40 of their brief, the one with the Metropolitan Police Department and one with the Department of Transportation are sort of direct contracts involving the district and the construction company? Do you dispute their description of those the existence or description of those contracts?
I don't dispute the existence of the contracts. The one I'm thinking of, I can double check, had to do with the purchase of police cars, not construction.
There's 2 there. There's a Department of Transportation.
No, I don't dispute the existence.
Okay. Okay. Any questions from my colleagues?
No.
All right. Thank you very much. The case is submitted.
Case number 21-1214 et al. District Court petitioner versus Federal Energy Regulatory Commission. Mr. Hughes for the petitioners, Mr. Flynn for the intervener for petitioner PJM Interconnection LLC, Mr. Estes for the respondent, Mr. Mays for the interveners in support of the respondent.
Good morning.
Good morning, Your Honor. May it please the court, Paul Hughes on behalf of the petitioners. The PJM capacity market is critical to ensuring that in times of emergency, sufficient power is available. The February 2021 winter storm in Texas illustrates the power emergencies may be catastrophic, and the 2014 polar vortex event gave rise to the market structure at issue here. This case addresses how capacity suppliers may bid into the PJM capacity market, and we submit that FERC erred in three distinct respects. First, FERC earlier correctly said that capacity suppliers could account for the lost opportunity of bonus payments. FERC's reversal is unwarranted and unreasoned. Second, in providing for unit-specific offers, FERC disallowed significant risks that capacity suppliers undertake because of the capacity commitments. This is arbitrary and capricious. Third, FERC is wrong to claim that the capacity sellers lack Section 205 rights. As a textual matter, Section 205 clearly encompasses capacity offers, and the court squarely held in Atlantic City that participants in the PJM market cannot qualify as a concession of Section 205 rights. I'd like to take those in order, but of course I'd be happy to begin anywhere the court may like.
Do you dispute that the March 2021 determination that the default offer cap was too high?
No, Your Honor, I don't think we dispute the earliest determination that there was a miscalibration of the anticipated emergency hours. And so I think there was an understanding at the outset when the structure was put in place, this court recognized advanced energy, that there would need to be likely recalibration of the system, and I don't think anyone disputes that. I will say many of FERC's arguments go to disputes about how the 2016 capacity performance structure operates and challenges to that. And to many of those, I'm sure we'll go through several of them, we don't disagree that FERC has objections to the 2016 capacity performance. That's not the basis of our claim. The basis of our claim is the new tariff that was implemented in 2021, we think for these very discrete but very important reasons, fails FERC's obligations under the Administrative Procedure Act. So we don't object to the notion that there was a 206 finding, a complaint, a finding of unjust unreasonableness. What we're concerned with is the replacement tariff that was implemented and core defects that are in that replacement tariff. So turning to that first core defect is FERC's abandonment of opportunity cost arising from foregone bonuses was just clear error. So this performance capacity structure, which still exists in relevant part, creates penalties and bonuses. That's if you have a capacity commitment and you don't perform, there's a penalty. If you have a capacity commitment, you overperform, you have a bonus, or if you don't have a capacity commitment, you have a bonus. What FERC said in 2016 is that this system of penalties and bonuses creates opportunity costs, and a competitive market offer accounts for that risk and that opportunity cost. That was that core decision, and this court in advanced energy specifically looked at that and recognized that.
So you say you do not want to attack the 2015 tariff, but only what was done in 2021. But in so arguing, this court does not have to accept, does it, the proposition that FERC's explanation for what it has done now in 2021 draws on the experience it had as to what happened under 2015, where a number of its assumptions, a number of the parties' statements proved not to be demonstrated as was anticipated. And you start out here by saying you don't deny that some adjustment was or recalibration was needed. And so FERC came up with a recalibration. You don't like it, and you say why FERC should have done something else. But that's not really the issue, is it? The question is whether or not it adequately explained what it did and why. And the fact that you don't agree with the conclusion or even its interpretation of its experience is basically not relevant, is it?
Well, respectfully, I disagree with the conclusion you draw, Your Honor. I think I agree with much of what you said as to FERC changing from 2016 and finding an unjustness and unreasonableness of 2016, and then it had flexibility in some respects to craft a new system. I think that is true so far as it goes. But in adopting that new tariff, it had to still comply with the APA. And there are very specific, concrete ways in which it didn't do so. So
no, but what I'm getting at is the argument to the contrary is that it did so, but you disagree with its explanation. And I don't see the APA or the FBA requiring that you necessarily agree. And so that's why I think some of the statements in your brief are a little misleading. I mean, it's fine if you don't agree, if you give us reasons, but that's different from saying FERC never responded, never addressed the alternatives, when clearly, when you read its order on rehearing, it did.
Let me try to.
Isn't your burden to tell us why those explanations are insufficient?
Yes, Your Honor, absolutely. And so let me try to do that with a little bit more precision, because I think there are two in particular to focus on. The first is FERC earlier said that a competitive offer can account for opportunity costs. They've now denied the ability to account for opportunity costs, but they've never explained why opportunity cost isn't part of a legitimate offer.
Well, they come back and say something a little to the contrary, don't they? That's what I'm getting at. Is you want a different system, and FERC says, well, in the system we want, here's why we did certain things. So I just want to be clear as to why the opportunity costs that it allowed under the 2015 system allowed for these offers to simply be too high.
And this is, I think, the key thing to disentangle, Your Honor, is they've made the conclusion that the opportunity cost is too high. That is a different issue from what we're addressing. What we're addressing is if there is opportunity cost, and FERC doesn't deny there's opportunity cost, can you account for the existence of that opportunity cost? That's sort of a question one, is do you have the right to even claim the opportunity cost? Question two is, how do you calculate the opportunity cost?
So when FERC says, that's what I just need to understand in your argument. Are you disputing that the record shows that you are 3 years out able to accurately, within reason, identify these costs, or is it really just speculation? I mean, so much could happen in 3 years.
And Your Honor, I think you can legitimately identify them, and FERC itself recognizes that. At paragraph 71 of its order in September of 2021, that's at Joint Appendix 1092, it recognizes that sellers will have the ability to estimate this, and that there will be a variation of ranges. So that's point one, is FERC recognizes these are things that can be subject to estimation. The second point is FERC has retained the very penalty and bonus structure at the heart here, which includes these estimates. So FERC has not walked away from the notion of having that there is risk and opportunity costs in the system that exists inherent to those penalties and bonuses. If FERC wants to say that we're going to scrap the entire system of capacity performance perhaps, Your Honor, then you say there wouldn't be opportunity costs in the system, but they've not done that and they've kept those estimates. I don't think it's appropriate to say that you have estimates for one part of the tariff, but then you don't allow estimates when it comes to actually providing capacity suppliers compensation or the ability to recover that in a market-based offer. And so again,
when do you know what it is? And FERC says, we are unpersuaded by what was presented to us that these costs can be, other than speculative, 3 years out.
Well, FERC expressly at paragraph 71 does not say these are not calculable. FERC says that these are things
later.
Well, I think if it does, Your Honor, it would contradict itself at 71 because it says the party suppliers can provide estimates and then there can be determinations that are made in this regard. And the existence of there being an ability to estimate is inherent in the fact that there still is the bonuses and the penalty structure, because that's also based on an estimate. And so given that the bonus and penalty structure was inherently based on an estimate still exists, I don't think they can say that we can't, calculate it for this point. And the third part is just the capacity markets themselves inherently reflect predictions. Now, they're educated predictions about what future markets, generally 3 years in advance, are going to look like. And that's why when FERC engages in this sort of rate making, it recognizes that what it predicts may have to change and that there has to be some iteration, or as we said at the outset, recalibration. So that's why we don't think it's a surprise that the values that were earlier picked need to be recalibrated. We're not disputing FERC's view that, again, to Judge Child's question opening argument, we don't dispute that the recalibration was needed and that there has to be a dynamic conversation about setting these rates. The point is, if FERC maintains the structure that it's maintained, such that there are penalties and bonuses, there are real costs that are imposed on capacity suppliers. And in 2016, FERC said a competitive offer includes compensation for those legitimate costs. FERC has never said that is wrong. They've now said it's harder to calculate. And again, I think FERC's best argument is at pages 62 to 63 of their brief, where they point to paragraph 24 of the rehearing petition for the point that where they say the opportunity cost was set too high. But when you look at the rationale, the reason for that, FERC explains it at paragraph 25 of the rehearing decision. That's the Joint Appendix 1243, straddling over to 44. What FERC says is, quote, the formula used to calculate opportunity costs established in the capacity performance order is no longer just and reasonable because it incorporated an excessive expected PAI, that's excessive expected emergency hours. This is a justification to fix how it calculates opportunity costs. It's not a justification to say that even though there's opportunity costs in the system, the capacity suppliers can't factor that opportunity cost into their offers when FERC had previously said they could. They just haven't given a reasoned explanation for that very poor, narrow issue. And it would be irrational, I think, if they were to say, yes, these costs exist, but capacity suppliers can't account for them in making a competitive offer.
We're essentially talking about rates, though, right?
Yes, Your Honor.
But has that ever been used consistently in the case law?
Sorry, Your Honor.
The term rate, is it even used consistently?
Well, and Your Honor, are you addressing the Section 205 argument
Yes.
about the meeting? So I think that the core is that FERC certainly agrees that the outcome of the capacity auction is a rate. And we think that a bid into that, which could set that outcome, is certainly a rate demanded. I don't think FERC has a particularly powerful textual argument to say that a bid that they recognize could set the clearing rate, could be the marginal price, is anything other than a bid demanded. Now, or a rate demanded. And I think FERC's key argument, actually in the Section 205 argument, is what they suggest is a capacity supplier isn't actually demanding the specific bid, that they're demanding the clearing price. But that argument can't be right, because if a capacity supplier's bid is more than what the clearing price ultimately is, then they just won't sell into that auction. They'll have demanded a rate more than where the auction closed, and they simply won't sell. They'll have demanded a rate, they won't have gotten it, so they won't have sold. So I don't think it works for FERC to be able to say that we're somehow just demanding the the clearing price when that may turn out to be incorrect. FERC's other argument that I don't think is really a textual one is just sort of a pragmatic argument, is that these are inputs into the rates. But I think FERC itself has been inconsistent with that point. If you look at this court's Exelon decision, what I think is important is the remand decision that was issued by FERC after this court's Exelon decision. And FERC talks about that at paragraph 121 of its rehearing decision. That's at the Joint Appendix, page 1294. And in that remand decision, what FERC recognizes is, although there's a complex procedure, but that capacity suppliers, they can essentially tag onto the ISO New England's Section 205 filing. But what's critical is FERC recognizes that if there is a capacity or a retirement delist bid in the ISO New England system, that is also an input into the auction. FERC recognizes that there are Section 205 rights and that the capacity supplier's retirement delist bid will be accepted if the supplier demonstrates that it's just and reasonable. And now, FERC's response to that is ISO New England has a different tariff structure than PJM. And that's true. But the question is, what's the meaning of Section 205 of the core term Your Honor asked of rates demanded? And if they recognize that an input into the auction for purposes of ISO New England qualifies within the meaning of rate, of a rate demanded, I don't think they can turn around here and say the input, the capacity bid, the capacity offer into this auction is not a rate demanded. It is textually, and it accords with what FERC has done in other cases. So on the Section 205.
Can a capacity offer be considered a rate?
Yes, Your Honor, I think it is the rate demanded. Now, that doesn't mean that
some of those are deemed confidential, right?
It is, Your Honor. And to be sure, there's a default under Section 205 for rates to be made public, but that is not inherently the case. What both 205C and 205E have as a preface to those provisions providing public notice of rates is, unless or to the extent that FERC regulations and orders direct, I have the precise language, but it gives FERC some flexibility. And I presume in a circumstance where FERC thinks that offers should be kept confidential, they would exercise their statutory authority to have some narrow exemptions to the publicity or the publication requirements, which I understand, or I think they are doing in ISO New England with respect to retirement delist bids.
Now, FERC did consider your alternatives, but then they ultimately decided that it would not have changed the conclusion about the offer cap.
Sorry, back to the first. Yeah, sure. It's true that they dislike the alternatives that we have given, but I'll say I think the more fundamental point, and FERC tries to suggest that the selection that they chose is permissible under the APA because they think our alternative option would have led to different policy outcomes they dislike. I'll say even if you grant all of that, that's not a basis to find that what they did do is compliant with the APA. And that's our fundamental point, is that disallowing opportunity costs is not compliant with the APA because there's no reason to back away from that, and it's just irrational. And let me just touch for a half moment on the second argument in our brief, which is there's this whole category of risks that capacity suppliers face bidding into the market, in addition to the opportunity costs that FERC has just fully disallowed.
You didn't argue about opportunity costs in that portion of your brief, correct?
No, this is. No, please, sorry.
I'm trying to make sure I have things straight in my head. So maybe if I say it, you can tell me I'm wrong. So the costs you're talking about here are distinct from the opportunity costs.
Yes. So what we're talking about, and this is under Roman 2 of our briefs, this is a distinct set of risks that capacity suppliers face. And these are things like risks of system-wide plant outage that would forbid a supplier or a generator from performing. And what FERC's key argument is to say is, well, you can't factor that into a capacity bid because they've basically hermetically sealed what they call on the one hand capacity risk, and on the other hand, energy market revenue risk. And they say you can only look at the risk for capacity, that is capacity as capacity, for this, and we're going to disallow anything that goes into the energy markets. But that structure, that argument, I think falls apart. It's just arbitrary and capricious for a variety of reasons, but the most straightforward one is what is in fact the formula for the offer cap that's at issue here. So the market seller offer cap, this is in the tariff at section 6.4a. It appears at Joint Appendix page 620. The formula is avoidable cost rate minus projected PJM market revenue. What our argument is there are a series of risks that necessarily go into what the projected PJM market revenues are. FERC is only allowing consideration of the first half of that formula, the avoidable cost rate, but they're not recognizing that the very definition, the formula used for the market seller offer cap also requires a projection of market revenue. And there is a risk that a plant may be out of service and not producing any PJM market revenue, and that should be accounted for as just a fundamental matter as to when you're calculating what the expected energy market revenue is. And FERC,
how does this argument differ from ones that were raised in the challenge to the 2015 order by, among others, Exelon?
So importantly, Your Honor,
and rejected by FERC then.
Yeah, this argument wasn't, so it is true, and this is one of FERC and especially the independent market monitor's argument saying this feature of the tariff design is consistent from the 2015-2016 order to today. But that part of the market design simply was not challenged. I mean, FERC tells us that at their brief at page 49, quote, no party challenged that holding on review. So when this court in Advanced Energy considered the earlier tariff, there wasn't a challenge to that.
But the same argument could have been made back then, but it wasn't made.
And there's a very practical reason, Your Honor, why it wasn't made is because of the default offer cap. As a practical matter, it wasn't putting...
Maybe a practical matter, but it seems like y'all had the opportunity to challenge it in 2015 and made a decision not to under your... This is something that has existed since the 2015 order, and it wasn't challenged then, and isn't it too late to challenge it now?
No,
and the only thing that's changed is we're not so happy with a different part of the program?
So both a legal response and a practical response to that. As a legal matter, there's no sort of estoppel or bar to that. This is a wholly new tariff, and there's an aspect of it that we've shown under this argument that violates the APA for being arbitrary and capricious. It's not a defense to an argument that's arbitrary and capricious, but the agency has been doing it for some time. I mean, if they had statute of limitations argument or something like that, or a collateral estoppel argument, those would be arguments, but they've not raised or lodged any argument. So just an argument that they've previously been doing something that we think we've demonstrated is substantively arbitrary and capricious isn't a defense to it not being arbitrary and capricious. It just wasn't raised and litigated. And again, there's a good reasons for that is because as FERC recognizes under the pre-existing system, most capacity suppliers use the default offer cap, and there wasn't this push into unit-specific review. Now, FERC has made much of the fact that this new market design is designed to essentially push virtually every capacity supplier into the much more onerous unit-specific review where their offer has to go before the independent market monitor, and all of these things then get factored in an individualized basis. It's that market design change that has made this aspect of the tariff now really, really important. And so the fact that this aspect is really important is now why there's a spotlight on this, and it being arbitrary and capricious is an argument that's being raised. But again,
well, so if Exelon, if I at least read Exelon's challenge as having raised this point before the commission with respect to the 2015 order, and the commission addressing it and rejecting it, then don't you need to show some basis on which something more than what could have been argued then, but it wasn't worth the time because you got what you liked on the default offer cap? FERC's going to be just flip-flopping from one order to the next, and that's generally frowned upon. So you need to show some reason why they were wrong in their analysis in 2015, so wrong that they should change their position now.
Well, two things about that, Your Honor. First, Exelon's not the only petitioner here, and I don't think any Exelon-specific argument will apply to the other 6 petitioners in the case. But second,
well, everyone else chose to let FERC know. They gave no signal they were unhappy and were living with it for quite some time.
But Your Honor, I don't think the fact that an agency has previously rendered a decision back in 2016 that wasn't reviewed by this court or any other court, therefore blesses it in some way.
Well, that order was definitely reviewed and upheld by our court, and people weren't even serious enough about the argument to raise it on appeal.
Yes, Your Honor, but the fact that that aspect wasn't challenged, FERC might be able to say that we've already decided this as a matter of FERC precedent. This is something that we've looked at and we can adopt the reasoning from 2016 here. Our principal argument, to be clear, as to this part, as Roman 2, is not some failure of reasoning in FERC. Our principal argument is it's substantively arbitrary and capricious, that this is not a result that can be countenanced because these are, in fact, real, legitimate costs. FERC has never given an argument as to why they're not legitimate costs. They've just said they're not costs that belong in the capacity supplier ledger because they go to energy market revenues. And our point is that sealing off these two things doesn't work based on the formula. So our point is that they just can't reach as a substantive matter this result. So again, even if the court thinks that there's something procedurally appropriate about FERC adopting what it previously did, I don't think that answers a substantive challenge to it being arbitrary and capricious. A FERC decision that isn't challenged doesn't, I think, become immune to later challenges when they re-adopt that same aspect of the tariff. And frankly, I think that sort of holding would be quite dangerous to say that a party, every time they think FERC has done anything in a tariff, has to bring to this court every conceivable challenge they have, or else, 10 years, 20 years down the road, when that aspect of the tariff gets reincorporated, reenacted, and actually becomes important, unlike before, that it's been immune from challenge. I don't think there's a legal basis for that, and I think the sort of framework that would set up.
What we do in ordinary civil litigation all the time.
Well, for issues that are in fact, again, if FERC had a collateral estoppel style argument, they could suggest that. But they
more res judicata. Claims that could have been brought but weren't.
Right, but I don't think that res judicata or collateral estoppel type argument has been advanced or developed in the agency review proceedings. If FERC had
you sounded like it was the most incomprehensible thing ever, but we do it all the time.
Well,
that's my only point.
I take the point, Your Honor, but just given the complexity of FERC cases as they exist, I think if the court were to set a rule where the first time FERC does something, you must immediately challenge, even if it doesn't immediately affect your rights.
Well, no, you did challenge and you lost and didn't seek further review. That's different than
one entity challenge it didn't seek review when it wasn't an issue that had immense practical importance. And again, I just don't think that the fact of a prior fee violation, I just don't think blesses this moving forward. Might finish on the Section 205 issues for a moment, or be happy to go anywhere else the court might have questions. So Judge Schultz had drawn us to the Section 205. As I said, I think the two issues are, is it within the scope of the text? And for reasons we discussed, I think the answer is clearly yes. If it is, then I think the only second question is, has there been some action here that has removed the capacity suppliers Section 205 rights? And I think this court's decision in Atlantic City is really quite impactful on that, because what Atlantic City says is, first, Section 205 creates statutory rights, and second, FERC lacks any power to force a public utility to cede those statutory rights. And I think the claim for ceding 205 rights in Atlantic City would be even stronger than that here, because there it was to participate in PJM market. The precise tariff says you'll have to give up your 205 rights. That's an express condition. And transmission operators voluntarily participated. And this court said, no, still, that's not the kind of voluntary waiver of these rights by contract under the Mobile Sierra Doctrine is the only circumstance that they would recognize where there could be a cession of the 205 rights. I think that what Atlantic City establishes quite squarely is that participation in the PJM market that act does not cede public utilities Section 205 rights. And I think that
we need to address Atlantic City if we accept FERC's textual argument.
If you accept FERC's textual argument that we're just totally outside, then that's right, Your Honor. But I frankly don't think FERC's textual argument has much weight to it, and I think that this is plainly a right demanded under just the plain text of that term. It's also, I think, consistent with what FERC has done in Exelon, but I think as a textual matter, this does qualify as a rate demanded. But I agree, Your Honor, if you reject that at the outset, then the second issue would fall by.
And your best authority that this constitutes a rate under 205 is, you got the statutory argument. What's your best case?
Your Honor, I'm not sure I have a particular case that has squarely addressed this. I think there's a lot of language in Exelon. It didn't, of course, it remanded without getting to a straight holding, but I think there's a lot of language in Exelon. But when
kind of cuts both ways, actually.
I would like to think it cuts more towards us, but I'd start though with, I really think this is a matter of plain text of the statute, and nobody disagrees that the clearing price of the capacity is the rate received. And so if that's the rate received, you know, the rates that capacity sellers demand in the auction is a rate demanded. And so again, it's not just the term rate, but it's also the disjunctive between received or demanded. And so I don't think a construction of Section 205 that limits it to the of the auction, which is the rate received, would do justice to the full statutory text, which also includes the rate demanded. And again, I think the scenario where you imagine a capacity seller who has a high rate and they don't clear, so they don't sell, that is a rate demanded. They didn't receive it because they didn't clear, but that still qualifies as a rate demanded within the meaning of the text. And the fact that the text has both rate received and rate demanded, I think inherently contemplates that there will be rates demanded that are not in fact paid or received. And that is squarely the context where you have a bid into an auction that doesn't clear. That is a rate demanded that you didn't receive. So I think textually we are squarely there, and there hasn't been concession of these rights. And I think, you know, the harm here to suppliers is significant, because otherwise this affects a very substantial shift of authority from capacity suppliers to be able to select within the zone of unjust or the zone of just and reasonable rates where to price capacity offer to the independent market monitor and PJM in a way that is quite inconsistent with the Section 205 rate. And you'll see this in a whole host of I think, day-to-day interactions, because this will come up in each one of these offers that now go to unit-specific review. So there are, you know, you can imagine a whole host, these are sort of mundane, everyday things, but now are going to be transformed pretty profoundly. So a generator who has many units will have various system costs, you know, one near and dear to my heart, perhaps avoidable expenses for legal services. And the question is, how do you allocate that among several different units that a generator might have? There can be different.
While you want to talk about statutory, only focusing on 205, there's a statutory scheme here. And you want us to ignore that aspect in interpreting Section 205. I mean, when you make an offer, I don't see where that establishes a rate. Rather, you're just asking for the market clearing rate. That's all FERC said in explaining why that argument didn't hold up.
Your Honor, let me be clear. I don't think our argument on this score is a lack of explanation. It's that FERC's.
I know that. I understand that clearly. But you're interpreting the statute, Section 205, in a way that FERC points out is basically inconsistent with other provisions of the Federal Power Act as to who's in charge of rates, et cetera, who reviews them, et cetera. And it's not the offeror. So that's all I was getting at.
Well, with respect, Your Honor, I do think I disagree with that, because Section 205
we shouldn't look at the whole statute, much less defer to FERC's reasonable interpretation of it.
Well, Your Honor, if there's a particular statutory provision that I could address, I'd be happy to. I don't think there is an inconsistency with other aspects of.
Well, I think some of the questions we've asked have already identified inconsistencies. Oh, no need to pursue it further.
Just, Your Honor, I think what the FERC's argument is that we're at odds with how they understand market mitigation principles. But, we fundamentally disagree with that because ultimately the structure.
That is not their explanation. So that's what I'm getting at. There's a whole statutory scheme here about how rates are made, how they're reviewed, all those sorts of things. And I realize you want to, on behalf of your clients, want a different scheme, but that's a different issue as to whether or not what FERC has said here is inconsistent with the language of 205.
But with respect, Your Honor, I think the whole statutory scheme sets a scenario where the public utility can select a rate, and then it's FERC's determination to decide whether that public utility has met its burden to show that that rate is just and reasonable. And we completely agree with the whole notion that FERC has the obligation to determine whether that rate is just and reasonable. I think what the court may be suggesting is my friends at FERC suggest there's inconsistency with our position and what this court held in Public Citizen and the nature of using the RTO tariffs as part of that market mitigation. And let me answer that directly if I can, because I think that might help. What the court in Public Citizen was addressing is how do we set up a structure where when FERC does not review individual rates, FERC can still make sure that it is adhering to its obligation to ensure that the rates in a market-based system are just and reasonable. And what the court's opinion in Public Citizen says, well, there's a structure for doing that, which includes complying with the tariff structure and also having ongoing monitoring by FERC of the market system. What that is addressing is the problem of how do you set up rules ex ante that ensure high confidence that you'll have just and reasonable rates without FERC reviewing those rates. And when there is a capacity bid that is done pursuant to that, then Public Citizens, this court's decision, Public Citizens say FERC has generally satisfied its obligations to ensure just and reasonable rates. What we're proposing, though, is when there's a disagreement between the PJM and the public utility, then that specific rate goes directly to FERC. FERC is ultimately in the role of decision maker to determine whether or not that rate is a just and reasonable rate. You don't have that situation then of trying to set up a system ex ante for how you ensure just and reasonable rates that FERC isn't looking at. FERC would in fact be looking at that specific rate proposed by the utility with any views from PJM or the independent market monitor and would make that determination directly.
It makes a determination whether that price is consistent with the tariff. But as Judge Rogers was explaining, the rate under our current system is this sort of open market tariff. It is a process rather than a number. And so when FERC reviews those types of claims that you're talking about, they say we're looking for compliance with the tariff.
But here's, I think, the critical question is, the tariff is not just one big mathematical formula. There is numerous kinds of discretionary decisions that get made into the inputs for that. So, one example that my clients have supplied is when they have to do certain maintenance, a stator rewind, whether or not they're going to use new copper or used copper is a determination they might have to make. And they might want to use new copper, but the independent market monitor might say your bid should be priced on the basis of used copper. Tariff doesn't control this. It's not, a yes or a no. It's a question, it's a judgment question. The question is, what's the range of reasonable? Where does this fall within reasonable? The core part of the Section 205 right is if the supplier has a 205 right, if its judgment is reasonable, is within just and reasonableness, it can select that for deciding the inputs into the tariff. If, though, FERC is correct, then the independent market monitor can change that, and if PJM agrees, then the independent market monitor's views override the supplier's, even if the supplier's offer the view was a just and reasonable. The independent market monitor doesn't have to find that it was unjust and unreasonable, nor would the independent market monitor have a statutory authority to find unjust and unreasonable. That's the point, is it's taking away that clear discretion from the inputs that go into the tariff. The structure that FERC has established under this petition for review of saying compliance with the tariff what that tariff sets up is when you have these discretionary determinations, is it new copper, is it used copper, that selection is made by PJM or the independent market monitor, not by the public utility. And so that's, I think, where the rubber really meets the road and why the key flexibility for the generators is important and it just isn't some abstract concern. But it's completely consistent with ensuring that there's market mitigation and FERC review of just reasonableness, because to the extent that the tariff, based, the approach where PJM disagrees, then it goes directly to FERC, and FERC is not using ex ante, rules where it's kind of guessing blind as to whether or not that rate is going to be just and reasonable. It's looking at the specific proposal, and it can make an up or down
comparing it to the tariff.
Sorry?
And comparing it to the tariff.
The tariff is going to be very important. Yes, Your Honor. I mean, if the argument is that we're going to do something that's completely inconsistent with the tariff, I don't think FERC's going to take terribly long in saying that's unjust and unreasonable. But what we're focused on is not, is this outside the tariff or inside the tariff? This is, how have you allocated these cost factors?
I think we understand. Unless my colleagues have more questions, because we've kept you up for an awfully long time. You have more questions?
No.
Okay, thank you. Mr. Flynn for PJM.
May it please the court, Paul Flynn for PJM Interconnection. So PJM's concern about FERC's order is that what do we care about? We want to make sure that there is no exercise of market power, but where there is a real legitimate cost the supplier has, we want to make sure they have a reasonable opportunity to include that in their capacity so that we are not deterring folks who would be submitting offers the same way they would submit them if there was a competitive market and they had no market power. Say, no, you can't do that. And we think that that's what happened below, that FERC overshot. It went dramatically away from the capacity performance construct and its practical effects in a way that overshoots. And what we're hoping is that you will send it back to them and say, FERC, you overshot in a way that you didn't adequately explain. Go take another look at this. Because some of this stuff needs to be recovered, whether it's in the default or in the unit specific. Because the end result of what FERC did was it took it out. In effect, that's where we're at right now. So specifically, how did FERC get it wrong below on this issue of opportunity costs and these other ones?
Opportunity costs and the default offer cap issue, and then I'm sorry, I didn't hear what your other one was. Is it the sort of? Yeah, in my mind, I'm calling the sort of the energy market costs.
Right. The opportunity costs.
Specific. Right.
I'm sorry. Were you finished?
Oh no, I'm just trying to make sure I'm
the
thinking
opportunity costs and the other risks. On the opportunity costs, the fundamental problem is they sort of threw the baby out with the bathwater, because the real problem was the difficulty, the fact that we haven't had the number of performance assessment hours or intervals that we're expecting. And so based on that, FERC found that the existing rule was not just unreasonable. But FERC went well beyond, there's a problem with the performance assessment hours, to say, no, we're throwing out the entire approach of having any possibility of including the opportunity cost of avoiding these, of not getting these bonus payments that fast performance still provides. But you can't include those in the offer now, under no circumstance. So they just went too far, and they never really came to grips with the fact that they went too far. They came up with this idea, well, that's energy. Shifting gears.
Mm-hmm.
But they never really explained why you have to go so far as to throw out the entire approach of allowing these opportunity costs, as opposed to something that
I thought that they said that the producers here so grossly overshot that they were exercising market power, and that no one seems to challenge that, and that I'm just talking about the bonus. That cost right here.
The reason they grossly overshot was because we were assuming 30 hours a year, and there were almost no hours.
Well, exactly. And so if it's an almost zero number, and the other proposal was simply to increase penalties, but still not address the problems with a reliable computation of what this opportunity cost is, especially given that over time it was looking like it was approaching zero, and no one was given a more reliable method for computing that, then why isn't it within FERC's discretion to say, you gave us something that was completely broken? Your backup, your plan B here is no better. It leaves the same problem in place that we still can't measure with any reliability, opportunity cost in a way that will ensure no one's exercising market power. And so instead, we're going to shift to this unit-specific approach. Why is that not within FERC's discretion?
Well,
And I'm sure they'll explain it better than I am, but that's my shorthand of it.
for one thing, you could still have performance assessment still exists in the tariff, and they still may occur. And when they do, then some people will pay penalties and some people will get bonuses. And so that is a real thing that still exists in the tariff.
When was the last time bonuses were paid, according to this record?
I'm not sure that there were on this.
This record, right? That seems part of the problem, because it seems like they haven't been charging a lot of penalties either. So that seems to confirm their point. There's really no way to measure this. So we're going to go, and we had such a problem of market power exercise with this approach that we're switching to unit specific, at which point then you have, I know, a separate argument about the problem with, as you perceive it, with what they did under unit specific cost analysis.
Right, and on that point, on the issue of these other risks, their answers were, oh, that's energy. B, we resolved it in the capacity performance orders, and C.
I'm sorry, I didn't hear the rest. I apologize, I didn't hear the rest of your sentence. So that's energy marketing.
FERC's rationale for not allowing the additional risk was, number one, oh, that's an energy risk. Number two, we already resolved that in the capacity performance order. And number three, you're asking for the sun, the moon, and the stars to put in anything you want. And so what I would say is on the energy risk, from PJM's perspective, what's going on here is that when you submit, and this is our concern, when you commit capacity to our region to help us out to keep the lights on the worst day of the year, we want to be sure that if you have additional costs that you're going to incur from taking on that capacity commitment, then you should be allowed to include those in your offer. And that would be a cost-based offer. And so where you take on a capacity commitment and you now have an obligation to enter into the energy market every day, which you do not have otherwise, that is an additional cost related to taking on a capacity commitment. When the price you're permitted for capacity is determined as the difference between all your costs and an estimate of what you'll get in the energy market, then at that point, what you will get in the energy market is directly pertaining to whether what you got in the capacity market is reasonable, and can you reflect some level of uncertainty in that when you are submitting your offer into the capacity market. So from our perspective, these do relate to capacity. They do affect whether, let's suppose a competitive seller with no market power, that's the type of thing they would think about in deciding whether or not to submit an offer into this capacity market and whether they can submit an offer that will clear.
I thought, as I read FERC's order, they said is, we'll let you include opportunity costs as long as they are, and again, I don't have their exact words at the tip of my tongue, but sort of verifiable and objectively, you show that they're sort of computable in a rigorous way or a verifiable way, again, to avoid market power concerns. And the problem is that a lot of these other costs haven't been shown by the suppliers to be computable in any concrete way, at which point then, and we're only talking about risks anyhow, we're not talking about certainties, risks that are sort of aesthetic, and I know aesthetics are the word, too amorphous to actually compute in a concrete, verifiable way, both creates, again, the same kind of market power concerns they had, the default offer cap, and it risks shifting 100% of this risk to consumers. So it's sort of two things as I read it.
Well, from PJM's perspective, we would only support it if it is something that can be documented and quantified.
Okay.
And it is currently the case that under the tariff that's resulting from these orders, you don't get these types of opportunity costs at all. The only thing that the tariff allows as a quote unquote opportunity cost is if you have the opportunity to make a sale in New York, for example, you could include what you could have got if you had made the sale in New York as part of the price that you can submit into our capacity market. That's the only opportunity cost. So it isn't it's not permissible to include any other opportunity costs in the tariff. So to the extent FERC suggested that in their order, that would have been incorrect.
Probably my formulation, to be clear of how I read it.
Well, and they are a little unclear on exactly what you can recover in the component of the unit specific, because the unit specific says here are all these categories. We'll lay them out in the tariff. These are the different categories. And one of them is capacity, performance, quantifiable risk. And what it says in the tariff is it's the risk that you will not perform under capacity performance. And FERC, in its characterization of that, particularly in the rehearing order, kind of suggests more than that, which is a little bit concerning because that's not what the tariff says. And we'd hate to say, oh, but you said over here that you could include a little more than that. And they would say, well, no, I'm sorry. The tariff just says you've got to tie it down to non-performance. So we see that as a bit of a problem as well, where clearly you could do that because the opportunity cost that was permitted in the prior default rate, which included the opportunity cost of, oh, if I'm not in the capacity market, I can get bonus payments. So if I am in the capacity market, I'm giving up bonus payments. Was closely related to this idea of penalties as well. And so there are multiple considerations that go into an offer under the capacity performance construct, not limited to the specific issue of whether your resource won't perform. And right now, at least the way the tariff is worded, that's all you get.
Okay.
As a result of these orders. And our concern is that's not enough. And that's what we try to convey to FERC.
Okay. My colleagues have any questions?
Nope.
Okay, thank you very much. Trustees for FERC?
Afternoon, Your Honor.
Good afternoon.
I'm Matt Estes here on behalf of the Federal Energy Regulatory Commission. I want to start with the Section 205 filing rights issue. I was a little confused about Mr. Hughes's argument. It sounded at first like he was claiming that offer cap provisions and tariffs, which substitute the offer cap and the tariff for an offer, violate Section 205 rights. I don't think that could be the case. It can't possibly violate your Section 205 rights to have to comply with the tariff pursuant to which you're making your sale. He then backed away from that by saying, no, it didn't really apply to that. It only applied here because somehow the commission has given the market monitor the ability to set the offer cap. But that's not correct. The tariff gives the suppliers the ability in the first place to propose an offer cap based on the formula. The market monitor simply reviews that offer to see if it complies with the tariff. And ultimately, if the supplier disagrees with what the market monitor determines, it can go to the commission and ask the commission to decide what cap complies with the tariff. It doesn't have to prove that the market monitor's wrong. The commission specifically said that was not correct. To the extent that Mr. Hughes is complaining that the tariff is not specific enough, that has nothing to do with their filing rights. They may or may not have some claim that the tariff should be made more specific. But that's a different issue. They've not raised that on appeal. They didn't raise that below.
Can I ask a fact question? If the market monitor looks at a proposal and rejects it, does the market monitor do any kind of written decision or explanation? And the same for if it's reviewed by PJM? And then do either of those get looked at by the commission if they take it to the commission?
I believe they do. Mike, you're going to hear an argument from Market Monitors Council. You might want to confirm that with them. But it's also, I just want to push back a little bit. The market monitor can't reject a supplier's proposal. It just says it disagrees. The parties are supposed to try to reach an agreement. If they don't, then the supplier goes to PJM and asks it to make its own independent determination. And if it disagrees with that, then it comes to the commission to ask it. And the just and reasonable standard doesn't fit in there at all. You correctly pointed out, the question is whether the offer complies with the tariff. The arguments on the commission's finding that an offer is not a rate, that was an alternate grounds provided by the commission for its decision. There are no precedents one way or the other on that issue.
I thought Public Citizen came pretty close.
Well, it didn't say that an offer was or was not a Section 205 rate.
Can you address the exclusion of risks, energy market risks under the unit-specific cost rate?
Yes. Well, the first thing to point out is the commission did not issue a new tariff with that respect. Those risks have never been included in the formula since 2006. And the type of risks they're talking about, the risks that you will underperform your estimated revenues, have always been there. All the commission did in this case was say, we're going to use the existing tariff. So I think there is a collateral estoppel argument. The commission did not say that in its orders. What it did say is, we've already rejected that argument. And it also pointed out that the suppliers never provided any other reason that things had changed now that would lead to a different result. So, and I also think that it's incorrect to say that the way the formula works precludes them from recovering their costs. It's important to remember that suppliers in a competitive market are not entitled to guarantee the recovery of their costs. The petitioners acknowledge that principle at page 40 of their brief. They're only entitled to the opportunity to recover their costs. And the formula specifically gives them that opportunity. The capacity calculation is intended to allow them to recover all of their costs that they would be expected to incur in the capacity market. And then you subtract out the projected energy revenues. Well, that means on its terms, if the supplier meets its projections, it's recovering all its costs. Yes, there's a risk that it might not meet those projections. There's also an opportunity to over-recover its costs if it meets its projections. The important point is it is given the opportunity to recover its costs. That's what everybody agrees they're entitled to. So, and that's the way this tariff has worked since 2006. I did want to briefly mention, going back to the Section 205 issue, Mr. Hughes's contention that an offer clearly is a rate demanded. What the offer says is I will charge X, which is the offer, or anything more than that that comes out of the capacity market. So it's really, I will charge, let's say, $10 or more. Under the standards for rates that have been established by this court, in order for a rate to satisfy the requirements of Section 205, it has to do one of two things. It either has to specify in the rate the specific price, or it has to set forth a formula pursuant to which you can look at the formula and determine what the rate's going to be. An offer doesn't satisfy either of those requirements, so I don't think it's clear that an offer constitutes a rate demanded. Moving to the opportunity cost issue, I was quite surprised to hear Mr. Hughes refer to paragraph 71 of the unit-specific order as representing a holding that the commission agreed that it was possible to come up with an appropriate estimate of what the emergency hours would be, because in fact, the commission said the exact opposite. It said it is difficult to come up with an estimate that is appropriate for general use. So, as you correctly pointed out, Your Honor, that was an important part of the commission's decision, that it didn't think the formula could be used because it didn't think it was possible to come up with the inputs to go into the formula. And that's especially important because the experience showed that there had been no penalties paid, which meant that there's no bonuses paid, which meant that in fact there were no opportunity costs incurred by any supplier.
But didn't FERC say that suppliers can include in their calculation the risk of non-compliance and facing penalties?
Yes, absolutely.
Well, and the bonuses are just paid out of the penalties, so I don't understand how you can compute one without necessarily being able to compute.
Well, you can compute the penalty. That's not the problem. The question is.
No, but the risk of the penalty. I mean, they're not including the amount of the penalty. They're including the risk of incurring a penalty and what that cost might be. FERC doesn't always charge penalties, and that is allowed to be in there. And it seems to me that that's really is just the other side of the coin from the bonuses, because the bonuses come from the penalties. I don't know how one can be calculable and the other can't.
Well, what the commission said in that same paragraph 71 of its unit-specific order is that while it's too difficult to calculate a generally applicable risk, that for purposes of calculating the risk that goes in the formula, that an individual supplier can have its own supportable evaluation of the risk. The problem is determining what should apply generally.
Colleagues have any other questions?
No.
Want to wrap up?
Thank you, Your Honor.
Okay, very much. Mr. Mays for the market monitor. Would you be able to explain to me a little bit about how this process works when someone submits a proposal to the market monitor and market monitor thinks it's inconsistent with the tariff? What kind of explanation happens, and if you know what kind of explanation happens for PJM?
I'd be happy to talk about the process. So we have staff that talk to the various participants about their offer. They provide us information about their costs, very confidential information that we review. We look at the rules for how you calculate an offer cap. And we also provide the piece of the equation, the net revenues. We come up with a level of an offer that we show them what we think the level is that would be a competitive offer. They come up with their offer. We go back and forth discussing it. Usually, almost always, we come to an agreement. Sometimes we don't. Sometimes the participant wants to offer at a level higher than what we think is competitive and appropriate. One thing that the process requires is for them to provide that level. So and they're committed to their level, even though it's higher than what we think is a competitive offer. They tell us what that does is it allows us to evaluate the impact if they go forward with that offer into the market, whether it, we can look and see whether, what the likelihood is that it would raise market power and consider whether we would need to go to FERC about that. And the other piece of the process is then, if there remains a dispute, it would go to PJM. PJM's role is to review compliance. So they're really looking just at the tariff and whether or not the proposed offer complies with the tariff. And they may decide that it does comply with the tariff, even though we disagree with it. And if that happened, the participant is permitted to offer at the level that it committed to. And it's responsible for that offer, including whether that offer constitutes an attempt to exercise market power. We would evaluate the likely harm from allowing it off in the market. And if we determined that it was necessary, we would take the matter to the commission in a complaint or other action. But typically it would be a complaint. And we would bear the burden of proof to show that the offer was unjust and unreasonable, that it was not competitive, and that it constituted an attempt to exercise market power, and we would have to litigate any issue we had with compliance.
And do you issue some sort of written decision explaining your rationale?
We explain our rationale in conversation. I don't know if there's a formal process where we issue a letter detailing every dispute, but it certainly comes up, and we would provide that information if a participant asks.
How does PJM know if they take it to PJM, how does PJM know the basis for your decision?
We communicate as part of that process. We're required to notify PJM of the level that we come up with and the level that the participant comes up with, and we have robust discussions with PJM about that.
Are you aware whether PJM issues any kind of written decision?
I think I'm not aware of what the content would be, but they tell the participant whether they find the offer compliant or not. So the participant knows whether it can go forward with that offer in the auction. Okay. This all occurs in the days, maybe the 190, about 100 days before the auction, with the idea that we will ex ante give information about the nature of the offer before the auction. So it's to provide more certainty and confidence in the eventual auction results.
My colleagues, questions?
Yeah.
Okay, you can wrap up if you like.
Can I proceed with my statement?
I'll give you about 30 seconds.
Okay.
Wrap up.
So, the purpose of the market monitor, as we've talked about, is to protect competition in PJM markets. We bring issues to the attention of those who can act to address them. We don't make those decisions. To get to some of the issues that we are confronting in this case, one is the nature of the net ACR offer. And we've discussed that offer has been in place since the beginning of the PJM market in 2006. That market, it has always accounted for some risk. For one thing, there's a 10% adder on top of all the costs that go into ACR. There is room to account for risk in that. And then there are the cost components. The purpose of the market is to provide capacity when needed. That's what the capacity product is. And the cost that we're looking at are the cost to provide capacity when needed. And when the participant is determining whether to spend money, part of that money is spent to address the risk that it will not be able to provide the capacity when needed. And for example, there's an important provision called project investment. And so if a unit were concerned that it would not be able to deliver capacity when needed, it would spend more money to try to make its unit better and more capable. And so that cost of investment would factor into the offer. So the risks were accounted for in costs. Risks were also accounted in the provision that we've talked about specifically, the capacity performance quantifiable risk provision.
Okay.
And that provision is very reasonably limited to costs that are quantifiable and reasonably supported.
Okay. So
we don't think much of the arguments about risk and the avoided cost offer.
Okay, great. Thank you very much. Mr. Hughes, we'll give you 3 minutes.
Thank you, Your Honor. I'd just like to start briefly with the Section 205 issue. And the argument that we have to comply with the tariff we submit is just too simplistic. I don't think there's a disagreement about complying with the tariff. The issue is these are far more complex calculations that they require judgment calls. I gave the example earlier of new copper, used copper. Let me offer a different example that comes from FERC's rehearing order, paragraph 57 to an appendix page 1259, where FERC says, quote, there may be more than one just and reasonable expected PAI value. That's the expected emergency hours. FERC recognizes that the inputs into the tariff, there can be more than one just and reasonable value. That's the whole point of rate making. There just isn't one value. The question here comes down to not complying with the tariff, but when there are multiple reasonable options, how is that selected? And the way that this structure is set up is the supplier makes a proposal, the IMM disagrees, it makes its alternative proposal, then it goes to PJM. If PJM rejects the supplier's proposal, then the independent market proposal becomes the rate. Now, you can petition, as the courts mentioned, to FERC to have FERC see if there's compliance with the tariff. But I think it's going to be very difficult for a supplier to show there's not been compliance with the tariff if the rate that's selected is somehow within the tariff. But the problem is you've shifted who gets to select the just and reasonable rate from the supplier, who, if we're right about Section 205, should have that right, to the independent market monitor at PJM, we don't think should have that right. That's the core issue. The other practical problem is on a petition, we don't know what this petition to FERC is. If it's a Rule 207 petition, this may be something that is completely discretionary at FERC and may not even be something that FERC has to respond to. Briefly on rates, I think the court appreciates our argument that the argument there about separating energy and capacity just doesn't hold up. We think on opportunity costs, FERC has identified in paragraph 71 that it can calculate risk penalties. The same should be true.
Okay. Colleagues, have any further questions?
No, thank you.
Okay, thank you very much. The case is submitted.